Yeah. Sometimes I get so mad, there's no controlling me. My thoughts get so bad, I'm like, I might grab a bag.
All right, everybody, welcome. Hopefully, if you were in the last stream, I'm going to give everybody a chance to get in here. But I thought, you know what, I'll speak a little bit while that's going on. If you were in the last stream, we were in the middle of the cross-examination of Robert Tellis or Tellis, however you want to pronounce it. He's still there. This is the spot we were at. And this will be the conclusion to this trial. We're going to be concluding with day 7. And then there's a day 8 and a day 9. Day 9, and then there'll be the verdict. And then if there's a sentencing hearing needed, there'll be a sentencing hearing to follow, as I was explaining in the last stream. In Nevada, if you're found guilty of a crime, a jury gets to hear gets to decide on your punishment. In this case, that punishment would be 50 years with the potential for parole eligibility after 20 years, or life with parole eligibility after 20 years, or life with no parole. Also, another thing that we're doing here, if you have a question, you have a quandary, you have a comment you want featured, something you want me to address, you will get my attention because I'm in and out of these streams, but I will come on and live address any question, concern that's put up through Super Chat. On top of that, we're going to be doing a super drawing, and that's going to be an exclusive drawing to anyone who's done a Super Chat on the channel. And this stream is one that's involved in past streams as well. I'll go back and look and see everybody who participated at a $5 or more. Gets the opportunity to get entered. Every $250 done for Super Chat, in addition to you getting your question featured, your comment featured, you get entered into a drawing to win an exclusive hat, Justice as a Process hat, exclusive merchandise, and we will send that to you. So if you have a question, if you have something you want to get popped up at the top of the chat, use the Super Chat button. Super thanks button also get you there as well. $5 or more, you get an entry. You get 2 entries, actually. For the first one, every $2.50 that you do after that first $5. So if you did a $10 Super Chat or Super Thanks, you're getting 4 entries. So anyways, a little something to do there, as well as getting a question answered, something concerned, something you want to see about this case, something you want to know about this case. We will put it in the form of a Super Chat. I'll come on, we'll talk about it, and we'll make it happen. So I'm seeing some people jump in here. We've got about 8 with us. I'll give it a little bit more time, and we will get started. So let's see here. So for those of you that are coming in to the stream here, we are watching the Vegas politician trial. Just happened in Hugo Silva says Wade Wilson case. No, this is not the Wade Wilson case. This is the Vegas politician trial. Although I did cover the Wade Wilson case. I have a full playlist on that trial, and I will be featuring it. What the format, if you're wondering how this channel works, what you're seeing. We cover trials. You will see featured live premieres where I will premiere trials. They're edited, they're cut down, all the garbage breaks and stuff are out, so you can watch it normally a day of trial, anywhere from 3 to 6 hours. Those are going to pop up. We do feature trials where I'll sit and watch the trial daily, and it's in a little bit of a different format than what we're doing right here. And then at night, when we're having fun, we come into the vertical lives. This generates a lot of people, gets a lot more people, a lot more views. And I will take my trials, premiere trials that are the ones I'll use for this, and we'll watch it together. I'll be in chat, in and out of chat. Like I said, we do super drawings, give away merchandise, stuff like that, talk, interact. On top of that, I also cover news around the justice system. So I'll do a vertical live on that, and we'll watch news clips. I have access to well over 350 news organizations that I am able to get my hands on clips. We'll play them, we'll react to them. There's a lot of interesting stuff going on. I also post up sentencing hearings, court hearings, you know, you name it, anything justice we're doing. And of course, we also have projects like, for instance, the Tyrone Tucker case, where we cover that case. And it's something that piques an interest. For instance, in his case, he's an innocent man being held. If there's a case you would want us to look into, want us to cover, you want us to get involved with, you email me at Justice is a Process. We'll talk about it, and we can see about getting some coverage on it, covering the case and giving it a look over. If you're wondering about my background, my dad was a well-renowned criminal attorney. He has since passed on, but he and I started this channel together, and the whole purpose was to inform people about the criminal justice system, because, as he used to always say, the justice system works better when people are watching. And in today's day and age, with COVID and the more cameras that we have in the courtroom, it was something he felt passionately about, something I feel passionately about. It was something that we were hoping to be able to contribute and be able to eventually grow our footprint to the point that we can start to make an impact in helping to get cameras in every single courtroom across the United States, so that we can watch, we can see, we can be aware, and we can help people understand what they're seeing. Like I said, I've been around the criminal justice system since since I can remember. I worked at my dad's law firm. Myself didn't go that direction, went a different direction, went into the financial world. But he and I put this project together. A lot of it was also to talk about his life and his contributions to the criminal justice system. I myself have stayed around. I've got a tremendous history, something we'll eventually talk about on the channel if you stick around. I've got some projects that I'm working on in regards to all of that. My backstory, talk about my dad's backstory. It's quite interesting. He's probably the best criminal defense attorney you've never heard of, and was one of the best in the state of not one of the best. He was the best and still considered the best criminal defense attorney in the state of West Virginia, in the surrounding area. And was involved in lots of cases. He was involved in cases you may have known, like the O.J. Simpson case. He was behind the scenes in that. So there's a lot of interesting stuff to share on that. But most importantly, we're covering, the point of this channel is to follow and show you cases like Robert Tellis. This is a gentleman who's claiming that he was framed, and we're watching the trial, and I want to see what you do. I want to explain to you, help you understand it, help you see it. So for those of you that are just joining, like I was explaining a few minutes ago, if you have a question, if you have a concern, if you have something that you want priority, I'm in and out. I'll be watching this stream all night while we conclude this trial stream. Put it in the super chat. And if you do a super chat, $5 or more gets you entered into a super giveaway that we will do in a subsequent live for the week. Covers all the various different lives that we've put on this week, that we put on. Anybody $5 or more gets $2.50. Every $2.50 you do, starting at $5 or more, gets you an entry. And this week we're giving away a Justice is a Process hat. We will send it to you. So that's something exciting for you. There's something we do just to give back to the viewership. Anyways, with that said, guys, we are picking up where we left off. We had a previous stream, and we were in the middle of Mr. Tellis' testimony. He was getting ready to, the prosecutor was getting ready to show him an exhibit. It's a good point to stop, because my streaming software only lets me go 8 hours. Now, this trial is already, before you see it come up on here, where I'm doing these vertical lives, and it's not in the most ideal format for watching. If you're watching at home on your TV or whatnot, we have a playlist. Every single one of these episodes is in that playlist, and it's curated, it's cut up, it's edited, so that it's ranging anywhere from 3 to 6 hours, depending on the day and what went on in the courtroom. We are about to conclude. So when you see these vertical live streams, we will fit 4 or 5 days. Sometimes we'll fit an entire trial in one stream. It's meant to introduce you to the case. It's meant for you to see a snippet in the case. It's meant for you to get access to me, ask questions about it. Like I said, we're monitoring and keeping track. You send us a question specifically. Like I said, we will address any and all super chats, super thanks. So that's where you put the ones that you want to have asked. You have a request, you have a case request, put it up. and you get entered into the super drawing of the week. So I can't beat that. Anyways, with that said, guys, we're going to jump in and pick up where we left off. Hit the like button, help get this stream known. And we're going to be watching this. Like I said, we're going to be watching this case for the rest of the evening. We've got a case that I want to bring up that I covered when my father and I were covering it when we first started the channel. I don't have daily coverage of it. It's the John DeLee case. That's going to be the next one we're going to cover on here, and we're going to be doing special coverage of it. And it's one that I'm quite passionate about. I think the jury got it wrong. I have a whole breakdown of the security footage in that case. It was one of the first things I did when I was starting out on YouTube. So that'll be coming up next. But for now, we're going to get through the Robert Tellis trial and go through that. Like I said, we also are right now debuting daily. So get subscribed. We're debuting the Kenneth Poole trial. It's a trial out of Georgia where he led a police chase. It's actually quite interesting. He led a police chase, flipped his car. Now, he says he wasn't driving. The state says he was driving. There were two guys in the car. One died. Now, in the other person that they wrecked into died as well. But the problem is, since they don't know who was driving in the car, Mr. Poole is alleging that he wasn't the driver, which means he's not guilty. And, of course, the other guy is not alive to tell. And the other driver who would have seen isn't alive either. So the state is actually having to put on evidence and prove that Mr. Poole was in the driver's seat. It's quite interesting the way they're doing it. Check it out. First 2 episodes, first 2 days of trial are already up. Day 3 premieres tomorrow at 9 a.m. Day 4 premieres on Monday. It's a 5-day trial. And then there'll be day 5 on Tuesday. It will wrap up, and then we'll be into the John DeLee trial next. Anyways, with that said, guys, we will jump in here and get it. GTTV, I have a foot fetish. Thank you, GTTV. I hope you get that taken care of. Anyways, all right. So let's jump into the trial here and go from there. Give me a moment, guys. We're going to jump in and start watching.
On June 13th, I mean, I don't know if you are aware of this back in the day, but an email is sent out. I'm sorry? July, sorry about that. July 13th of 2022, Jeff Garriman is making a public records request, correct?
Yes, sir.
Now, in July, you have already lost your race, correct?
Right.
So the election isn't at stake. Is that correct?
Right. Correct.
You will be gone in a matter of 6 months, right?
Right.
And now, Jeff Garriman is asking for all emails between Public Administrator Robert Tellis and Estate Quarter Roberta Lee Kennett from January 1st to the date that this is fulfilled, correct?
Right.
He also wanted all of your communications, including messages between you and Roberta, correct?
Right.
He wanted you to wanted the county to provide all text messages between you and Roberta, correct?
Right.
From your personal cell phones, correct?
Yes, he did, but he was not allowed to have them. But yes.
Sure. Understood, but I mean that's how far this is going. And additionally, and I didn't read that in the middle, it included a request for Microsoft Teams messages as well. Isn't that right?
Right.
Okay. Now, sir, you are familiar with the county's policy. Well, let's do it this way. You testified to this jury that, before the records request went out for the Teams messages, you had reviewed them and you didn't have any issues with them, correct?
And I'd love to elaborate on that if I could.
I need you to focus on my question. Yes or no?
I had an opportunity to. Yes,
Sir?
I did have an opportunity to review them before.
Judge, it's a two-way street on this one.
Okay, if you can answer the question, yes or no.
I haven't finished the question yet.
Oh,
Then I can ask Mr. Hamner if he wants you to answer the question.
I need you to listen. I need to finish the question.
Oh, I thought you were done. Sorry.
Well, yes or no, you testified on direct examination that you reviewed Teams messages and you did not have an issue with them, correct?
The production that I understood was going to be sent to Mr. Gurman, yes.
Right. And just to be clear, you were familiar with the county's policy about what gets produced in a public records request, correct?
Yes, sir.
And so, isn't it true that under this county policy, personal messages would not be produced under a public records request?
That is correct.
Okay. So any personal communications between you and her wouldn't go out to Mr. Garriman, correct?
That is absolutely correct.
And that is why, and so you're like, I don't have any issue with that other stuff going out, correct?
Correct.
Okay. But let's be clear about something. The election's over, right?
Mm-hmm.
And Jeff Garriman,
Yes, I'm sorry, Your Honor.
and Jeff Garriman seems to still be digging about you and Roberto, isn't that right?
Yes, but there's nothing to dig, provided obviously that
Well,
if he was going to receive what I saw, then there was nothing for him to dig.
I mean, you would agree, I mean, reporters typically don't ask for records requests unless they're planning on doing a story, correct?
Sometimes I think they're just fishing to see if there is a story.
And according to this records request, he's fishing about one thing, it's you and Roberto, right?
Right.
Okay. Which you told us back in May, when you sat down with your interview with Jeff Garriman, the number one priority was to, protect your family and not really dig into that, correct? Or
Not
at
really
least
dig into
disclose
it.
that, correct?
I'm sorry.
You told us when you met with Garriman on May 11th, you had said, I was truthful about some things, but I wasn't truthful about everything. The one thing I didn't want to talk about was the indiscretions. And you said that the reason for that was I was really concerned about my family, correct? Okay. The election's over. You're on your way out, and now this guy is wanting to ask more questions about you and Roberta, right?
Yeah.
It's not about you and Rita, right?
There's a I know that there was a later request for those other emails that got appended to this, but I don't know if you remember that with
But
Mike
just in
Murphy
this
and
specific,
Rita.
Hello,
just in
Carino
this
S.
specific
Welcome to
request,
chat.
he's not asking for communications between you and Rita, right?
Correct.
He's not asking for communications between you and Alicia, right?
Correct.
It's just about you and Roberta.
Right.
He's not leaving it alone, is he?
I think he's still fishing.
That had to have been frustrating, Mr. Tellis.
No, it was not, because I knew he wasn't going to have anything based on what I reviewed from the production.
Okay. So it's your testimony that the possibility of a fifth article didn't concern you at all when the potential source of the request is just about your communications between you and Roberta. You're telling us that's not a concern at this point in time.
Again, so I can explain to you how things,
Yes or no? Is it a concern or is it not?
not at the time that I reviewed those documents, no.
Okay. So now, let's now jump forward to August 8th of 2022. On that day, Dan Coolin emails you and starts to tell you about the production request, that it's going to start to happen, correct?
Yes, sir.
Okay. That's on August 8th, right?
Yes, sir.
We'll do this quickly here. August 8th. 4 days later, in your phone, the Google Maps and bronze circles start popping up, correct?
No, sir.
Read this out to me. What does that say?
That says August 12th, 2022.
Great. Publishing 364. This is the street surveillance. Please read out to me what the date is on that.
August 15th, 2022.
Okay. You would agree that August 12th is just 4 days after August 8th, correct?
I would.
You would agree with me that August 15th is just 7 days after August 8th, correct?
I would.
And if we go back to the overhead, 354. I want you to read the date on entry number 1 on that.
The modified date?
Yeah,
8/23,
okay.
2022.
I wish I could do the math on that one. I feel like that's like about 2 weeks after August 8th, correct?
Somewhere on there.
We also heard from Nicole Lofton, correct?
Yes, sir.
Nicole Lofton was employee of the public administrator's office, correct?
Yes, sir.
A member, as you describe it, of the New Guard, correct?
And,
She was
yes.
on Team Tellis, fair?
Sure, yes.
Okay. You had text messages between you and Nicole Lofton through the course of your time as a public administrator, correct?
If you've got them, then sure. I don't recall.
Okay, well, I'm going to approach for a second. So I'm going to show opposing counsel what's been marked as Exhibit 376. It's just an excerpt of some things, but take a look.
And these are just excerpts, they're not the entire.
It's not the full thing. There's a lot of messages there. I just wanted to kind of narrow down. I'm going to approach in a minute, but I need to get an understanding. By August, beginning of August 8th, by August 8th, how are you feeling about Jeff Gehrman's next upcoming article?
I don't recall.
Okay. Are you concerned at all?
I don't recall.
Okay. Well, let me show you what's been marked as Exhibit 376, proposed Exhibit 376. I want you to just take a minute and flip through those and let me know if you recognize essentially what you're looking at there.
Okay.
Getting close to it.
Do you have that timeline exhibit that was used during this direct?
Would it be a good time for a break as well?
Yeah.
Sure, we can do that. That's fine.
All right, at this time, we're going to take a break during this recess. You're admonished not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media, or read, watch, or listen to any news or media accounts or commentary about the case, do any research, consult dictionaries, the internet, or reference materials, do any investigation, test a theory, recreate any aspect of the case, or in any other way investigate or learn about the case on your own, or form or express any opinion regarding the case until it's finally submitted to you, and we'll be in recess for 15 minutes. Thank you.
All right, jury. Right there, will please be seated.
Does the state stipulate to the presence? Mr. Drafter?
Yes, Your Honor.
Okay, you may proceed.
Thank you. Sir, you had a chance to review those text messages?
Yes, sir.
That's a fair and accurate depiction of some of the text messages you had with Nicole. Would that
Yes.
be correct?
Yes, sir.
At this time, we'd ask that these be admitted, states proposed 376.
No objection.
So again, just to set the stage, like how are you feeling in early August about Jeff Gehrman and his articles?
Like I said, I don't know that I thought any way about Jeff Gehrman in particular,
Okay.
right?
Okay. All right. So we're just publishing these. Just kind of zoom in. So that's just the ones in green. That's you, correct?
Yes.
That's just the first page that goes back to August 17th of 2021. Is that right?
Yes.
All right. So this message is from June 15th. That's the day of the primary, or at least the day after the primary, correct?
Yes, sir.
I think you state, isn't it true, you state to her, good morning, poll results aren't in yet. It's about a three-way tie with me, last by around 2,000 votes. The precincts I'm counting on aren't in yet. And Nicole says, praying, right?
Mm-hmm.
And you say, me too.
Yes.
Turning to what's marked as page 64, just on the actual pagination. We look at this bottom email at 6:15 at 12 o'clock p.m. She writes to you, folks are prancing around like you conceded. Did you? Do you remember her writing that to you?
Not until I see it now, but it's been a while.
Okay. And then your response is, isn't it true your response was, no, I'll check the website to see if a winner was declared. And she responds, okay, correct?
Yes.
I think you indicate that if I lost, I will protect you until you can get a new position. Isn't that
Yes.
right? And she responds, I appreciate that. Is that correct?
Yes.
And isn't true then you say, I'm so sorry, Nicole, I tried so hard, I almost made a comeback, but it's done, correct?
Right.
And that's at 3:16 p.m. on the 15th, isn't that right?
Right.
And you say here, unfortunately, too many people bought the lies, isn't that right?
Right.
And when you're saying that, you're referring to the voters, correct?
Yeah.
And the lies were propagated by those articles, correct?
Yes.
That Mr. Gehrman wrote.
Right.
We look down here at the end, she says, I'm so sorry, will you work until the end of the year or resign? Isn't that right?
Yes, sir.
And she says, thank you for believing in me. Isn't that right?
Yes.
Fair to say she cared for you and how you treated her in the office, correct?
Right.
All right. And you told her, in fact, I very much believe in you. You have been my best employee. I'm so sorry that I couldn't pull it off. Isn't that correct?
Right.
And she lets you know that you fought hard. Isn't that right?
Right.
And we see here on 6:15, you even say to her, I'll stay on until the end of the year, although if they aren't messing with you, I don't know that I'll spend a ton of time in the office, correct?
Right.
Essentially ceding power to Rita Reed, correct?
Right.
And Rita Reed is friendly to Compass Realty, correct?
Right.
And so your intentions were to step away from that office or lower your profile even as early as June 15th of 2022.
Right.
So you would be less of a threat to Compass Realty even then, correct? Because you'd be stepping away and not spending a ton of time in the office.
No, sir. The evidence proves otherwise.
Okay? And then we look here at text on June 21st. Nicole says, now Alicia is in the other cubicle counting the files that were left in there. These people are so sick. They spend half the day trying to get you instead of working. The you she's referring to is yourself, correct?
I don't know if it was that or, generally saying you in that sense, like, because I don't have files in a cubicle.
Okay.
So it might have been, that perception that, I don't know how to explain that. I think you get it.
Contextually, she's talking about the old guard, correct?
She is talking about them, but as far as whether she's talking about herself or me, I don't know.
Understood. But she believes these people are sick, is that right?
That's her opinion, and, they did some pretty tough stuff.
Well, and it appears you share that same opinion. You say yes, like they think it all still matters, correct?
Right, like they're still trying to sabotage me, but it's pointless at this point, right?
Well, you say it's pointless, but we'll get to that in a second.
Sure.
You then also say she's probably trying to get fodder to pass to the reporter, correct?
Yes.
So the reporter is still on your mind, isn't that right?
Just from the standpoint that they're still trying to concoct things, and that's why I decided to stay away from the office so they couldn't concoct anything anymore.
Because the articles were damaging, correct?
They were damaging, yes.
Professionally and personally.
Primarily professionally, because obviously I had to figure out something else to do for work, which, again, I'm a lawyer, so I guess, rehang my shingle if I can, do whatever I can.
And that's a really interesting point. On August 8th, we've seen how that's the day you get notified that Gehrman wants stuff between you and Rita, correct?
Correct. Mm-hmm.
I want to look at what's marked on the bottom is page 110. Isn't it true that you tell Nicole at 12:28, you're dealing with a lot, I'm sorry. For me, this may have a long-term impact. I have people that no longer talk to me. Also, I'm worried in this digital age that the articles could potentially follow me around for years to come. I'm actually worried I might not have any good employment prospects after this, correct?
Yes.
And it just so happens that you were then informed that Gehrman is snooping around looking to potentially do another article, correct?
Yep.
And you're telling Nicole in confidence that you believe your future employment is jeopardized because of the articles, right?
Yes, but the damage was already done. So it's not, whether he wrote another article, he wrote 10 more articles, it was irrelevant at this point.
Well, apparently you don't say that, though, in your email. You don't say in that, that text message. You don't say, but the damage is already done, do you? You don't say that in that message, correct?
Well, it says that the articles are going to have an impact, and you would think that would refer to previously published articles, so I think that it's assumed that, it's done is done. So
Sir,
if he goes on and does 10 more articles, same net effect, really.
Right. Sir, to go back to my question, isn't it true you never use the words, the damage is already done, correct?
Not in this particular message, no.
Right. And you state, also, I'm worried in this digital age that the articles could potentially follow me around for years to come. I'm actually worried I might not have any good employment prospects after this, correct?
I'd say they'd be better than if I had actually murdered Mr. Gehrman.
So, sir, we're going to go back to my question. Isn't that what you wrote in the text message?
Yes.
And 4 days later, Google Maps images start popping up in your phone, correct?
No.
7 days later, on the 15th, surveillance is being conducted on a street, correct?
Not by me.
And on the 23rd, multiple images of Gehrman's information about what car he drives and where he lives is literally being screenshotted of your desktop computer, correct?
Not by me.
Because if it was you, that would be a big problem, wouldn't it?
Objection calls for conclusion. It's argumentative.
It is argumentative if
We'll
you
move on.
rephrase it.
No, we can move on. Publishing 342. Then you receive this email on 9/1, correct?
Yes, sir.
You receive it at 5:45 p.m.,
Yes, sir.
correct? And we heard from Roberta who talked about this, right?
Right.
And she had indicated that the release of the information to Gehrman was just around the corner, correct?
Right.
Let me find this.
And I knew in advance that it'd be only...
Sir, there's no question pending. At 5:45 on September 1st, you get the information. You get notified that Jeff Gehrman is soon to receive personal records requests related to messaging and communications between you and Roberta, correct?
No. It was not personal.
Okay, I didn't mean that. I meant, I apologize for my misstatement. Communications between you and Roberta, correct?
Business related, yes.
Right. And then at 11:20 in the morning, just a few hours later, Gehrman's dead, right?
Yes.
Let's talk about September 2nd, 2022. You had testified on direct that you had, your daughter had asked you a question, you responded around 8:48 in the morning, correct?
Yes, sir.
Okay. You said at that point you then hung out at home, correct? Mm-hmm. Around 10ish you went for a walk, correct? Mm-hmm. You said you...
Yes, I'm sorry, Your Honor.
You said you then came home, isn't that right?
Yes.
And you said that you went to the gym around 12 o'clock, 12:09,
yes,
correct? I think that's when you log in, around 12:09.
That's when I checked in using my phone at Planet Fitness.
Okay. And that's the Planet Fitness that's on like Fort Apache and Charleston, right?
Yes, sir.
Okay. And it's kind of just down that road, right? Down. What's the road? So you live on Spanish Steps?
Correct.
And then the road to kind of make your way out to Piggott, what's that one called?
South Tassel.
Okay, and then if you made a left to go by Piggott, what's that big road?
Red Hills.
Red Hills. And Red Hills can kind of get you up to that corner, right? Where the
You
Planet
can go through a
Fitness is.
roundabout. You can go north from there on Apple, and then you head east to get to Planet Fitness.
Okay. And I think what you had, before we do that, let me ask you this. So, what car did you take to the gym?
The BMW.
All right. Oh, so it's kind of, what's the color? It's not quite gray. It's not quite brown.
I think it's brown.
A brownish color. It's kind of metallic-ish.
Right.
Okay. And you took that route that we just talked about. That's how you got to the gym. Correct?
Probably.
Okay. Oh, another question. So, and we're circling back to something, but your belief is, what's Jappy's role in the conspiracy? What exactly did he do?
I'm not certain to what extent, but obviously he's the one who initiated the surveillance that was done on me that went from, I believe it was August 16th, all the way through September 7th. So despite his testimony also that they only do surveillance every other day, if you look at Cynthia Sauerland, the surveillance pages from that, you see that they're done back from, one day to the next. And, when I requested that these surveillance logs be provided to me the first time, I received only 3.
Okay.
Then when I pointed out the fact that there was a surveillance log on September 6th that mentioned September 1, then lo and behold.
All right, everybody. So need a favor of you. We got 59 of you here in chat. I'd like to see a few more likes. Help us get more people in, help the algorithm recognize this trial. This is the conclusion to the trial, so we want to get more eyes on this. And do your part, hit that like button. All you got to do is tap the screen. I've got the little button right up there. If you see behind me, right up here, you just double tap that like button, or you just tap that like button, and it'll put the like right on there for you. It's real simple, real easy. Do that, guys. And remember, for those of you that are coming in, right behind me, you're going to see there's the support the channel with a super chat of $5 or more, and you will get an entry into our super giveaway of the week, and that is giving away an official Justices of Process hat. We will send it to you. We'll reach out and contact you if you are the lucky winner of the super chat. And of course, super chats are a great way for you to get any questions about the case answered. Move a comment up. You're going to get your comment displayed. Whatever it is, it'll get displayed for a little while. So great way to do that. But for every $2.50, starting at $5, you get one entry into the weekly super drawing. So wanted to go over that, guys. Hit that like button, and we'll get back to the trial.
Well, now there was 4. Okay. I believe that there were actually surveillance logs for every single day, and they just weren't turned over to me. So I believe that, that Jappy knows that I didn't kill Mr. Gurman.
Okay. So do you think it's a little strange that if Jappy wanted to frame you for murder, he would clear you of all wrongdoings with the allegations of taking bribes?
I'm already here on this charge, so I don't think he needs to worry about another charge.
And so if the job's done, why waste his time with Compass Realty?
In what sense?
Well, he testified that after you got arrested, he spent another 4 or 5 months investigating Compass Realty and then brought charges to the DA's office. Why do that?
So, and this is an interesting point. Because if you look, well, I guess you can't look, but the file into me was over 100 gigabytes in information. That's quite a bit of information. The file into Compass Realty was only 3 gigabytes worth of information. It appears it was just a token investigation because, again, he didn't do the stakeouts that we discussed. He very clearly said that he believed that this personal property was leaving the homes. And it's shown in 500 pleadings that, again, there was no personal property taken from these homes, no vehicles that were actually, I'm trying to finish answering your question, sir.
Okay.
There were no vehicles, again, for which the titles were traced. He didn't investigate the issue with the homes being trashed ahead of time to lower their values so that they could basically net almost double on the next sale. So, again, that's, as far as I'm concerned, when he refuses to do a legitimate investigation on me, again, I'm doing just 3 gigabytes worth of data. I think it was just a sham investigation. He didn't do any of those other things he promised he would do.
Sir, isn't it true you told this on direct examination, you bemoaned the Attorney General's office for looking at your case for like a matter of a month and then just not doing anything with it? You did say that, right?
No.
You never complained about the Attorney General not taking your Compass Realty allegation seriously?
I did not bemoan and I did not complain.
Okay. Did you say they didn't take it seriously?
I didn't say they didn't take it
Did
seriously.
you say that they only looked at it for like a month or two?
They only looked at it for a month.
Just a month?
Yeah.
And Jappy looked at it for 11.
But again, he didn't do the things he promised
Yes
he
or
would
no? He looked at it for 11 months.
do. Yes, but it was a sham investigation.
Okay.
It was a bogus investigation.
Okay.
Didn't do what he said he was going to do.
All right. Oh, let's talk about Zach. You like Zach, right?
I think he dislikes me more than I dislike him. I didn't really, personally, didn't have qualms with him. I didn't. He didn't waste my headspace.
Okay. And that's good to know. The disagreement that you had, do you really think it was like a total fallout over this Ottawa property?
I don't. No.
Okay. Because to be honest, like you did continue to do business deals with Zach after Ottawa.
Yeah.
Right?
I think what Zach was upset about,
Sir,
if I may.
Sir, my question is yes or no. Do you continue to do business deals with Zach Schilling after the Ottawa sale?
Yes.
Okay.
Absolutely.
And now at this time, I'm going to show opposing counsel what's been marked as 388, 389, 390, 391, 392, 393, 394, 395, and 396.
All right. So wanted to say a big thank you to None of Your Business for the super chat. Want to let you know one thing to do. Make sure None of Your Business and anybody else who does a $5 super chat or higher, make sure you it's in your best interest to get subscribed for the week, because I will make the announcement in case you missed the live. We'll do the live on Sunday. In case you missed the live, I will do a notification on the community page announcing the winner. So that way, and I'll try to reach out to you and find the winner there, announce who it is. So if you want to have that turned on, so you get the notification and see the community post. Anyways, thank you again, None of Your Business. Let's see who else wants to come in. Again, if you have a question, you have something you want to see, something you want to know about the case, about what's going on, about what you're seeing, include that with your super chat. Let me know, and we will address that. It will get top priority. Anyways, thank you guys, and let's get back to watching the trial.
Sure. Sir, I'm going to show you first 390, 389, and 388. Do these look familiar to you?
Hold on just a few moments, because
Sure.
I want to look at where he actually changed realtors, because when I do my redirect, this is all going to become relevant.
Okay. Do you know what that is?
I do, but it doesn't say who the realtor was on this.
Well, and I would turn your attention to 388.
Okay.
Look here at the bottom.
Approach.
Sure.
Yes.
388. Does that help? Kind of help. I mean,
Sure.
look at the address.
Of course.
We got our address here,
Right.
and that corresponds to those documents. Do
Correct.
these appear to be like a listing agreement, kind of an order closing the sale of a certain property, a check going out to Mr. Schilling?
And yes.
And these all appear to be fair and accurate depictions of those?
And this is Ottawa.
The Ottawa
Right here.
property, yep.
And just let me write a note if I may.
Sure.
And you're okay with this?
Obviously, we're going to receive copies of this, so.
You have, they've been already
Right.
produced.
Put the date on it. So what is the date here?
Go to the back page, the very last page. I think it kind of shows some dates.
Okay. Yeah, thank you.
Okay. At this time, we'll ask for admission of stage proposed 388, 389, and 390.
There's no objection.
There's no.
And then I want you to take a look at 396, 395, 394, 393, 392, 391. And let me know if these appear to be listing agreements.
Yes, they are, sir.
Okay, and those are fair and accurate depictions of those agreements, correct?
Yes,
Mr.
sir.
Schilling?
Just 1 second.
Sure. Thank you very much. So, Ottawa was the property where you guys had some sort of disagreement about a valuation, right?
Yes, it was more a little bit of sour grapes on his end, but yeah, no, it wasn't, as far as I was concerned, a big deal.
Right. So, but when we heard kind of cross questions and testimony from Zach about there being this disagreement, Ottawa is the one that we're talking about, correct?
Ottawa's the one where he felt like he was cheated, but that wasn't the case.
Understood. And just publishing 388, this was kind of the licensing agreement to bring Zach Schilling on, correct?
Right.
And if we look here, oh, okay, it's showing up there. Zach Schilling is there. Sorry, this monitor's kind of cut off. 389 is a court order that establishes that the sale was approved for this Ottawa property, correct?
Yes, well, basically, it's just that this is the deed after the docs have been finalized, everything's done.
Understood. And publishing 390, we'll do it backwards, but that's like a check that got cut to Zach in relation to this property, correct? And the date on this is 3/22 of 2021, right?
Yes, sir.
Okay. So despite this disagreement, isn't it true that the public administrator's office continued to use Mr. Schilling for properties that you needed to have sold that came through the PA's office?
Yes, I never disputed that.
Okay. Well, I mean, we heard some testimony about like, oh, Zach didn't get a lot of business at Trail. I think Nicole may have said things like that, correct?
Right, and it's true that he actually had his business reduced, but I'll go into that.
Well, okay. So, but publishing 391. Oh, sorry. We're requesting that 391 through 396 be admitted to evidence.
I have an objection.
They're admitted and made public.
Thanks. So we've got here in 391, on June 8th of 2021, this is a deal with Zach, correct?
Right.
We've got another one here, 392, 612, another deal with Zach.
Right.
394, 716, another deal with Zach.
Yes, sir.
393, this is a 6/11/2021 deal with Zach.
Right,
Publishing 395, 8/14/2021, a deal with Zach.
right,
Publishing 396, 10/6/21, another deal with Zach.
right.
All postdating the big disagreement, correct?
It, again, was not a big disagreement, and as far as I was concerned, and the issue that he truly has with me will come later, and I can discuss that.
Okay, the bottom line is, money continued to flow from the public administrator's office to Zach Schilling for the work on these houses, on these deals, correct?
Not nearly as much at a certain point, but yes,
My
but
question is
yes.
Thanks. All right. I wanna, you mentioned you're a tech guy, right? A little bit of a techie?
I think you asked that before, yes.
Are you an Apple guy or a Google person? When it comes to phones, what are you?
Well, I have a Google phone.
Okay. I want to, we've seen this timeline, right? We've seen this timeline on publishing states 374. I want to turn your attention to this page. It's entries 23, 24, and 25. You covered these messages and calls from your wife on direct examination. Do you recall doing that?
Yes, sir.
I believe you had said that you were out walking around, you received this message, and then your wife called, and you just didn't want to get to her, get back to her, and that was kind of what happened with that. Is that correct?
Right, I was really close to home. I was going to walk in the door, so why? Or walk through the garage, I should say, and so why?
Right. And I think you said, "Honey, I'm home," right?
Something along those lines.
Because May was home at that time.
Right.
Okay. And that was just minutes later, right?
Mm-hmm.
Okay.
Yes, ma'am.
So there wasn't any concern, it was just a picture of your daughter in this call, you were just gonna take care of it, right?
Right.
Okay. Nothing else?
As far as messages and things go, or
Okay. Well, anything else you wanna add to this, sir?
I don't think so.
Your wife doesn't have a Google phone, right? She have an Apple?
Yes.
And she, Apple's got all these crazy products. They've got what's the thing that you put on your wrist that kind of goes with your phone? What's that one called?
Some of the Apple Watch.
The Apple Watch. Does May have an Apple Watch?
She does.
Okay. Did you ever watch Steve Jobs' presentations when he would get up and say, just one more thing? You ever see him do that? And he drops a new product or anything?
No.
Never seen that before? Okay. Well, let's take a look. I'm publishing I don't even know if I've shown this opposing counsel. This is just. May I approach the witness? Let the record reflect I'm showing opposing witness 378. Stage proposed 378. Those appear to be the messages that we're looking at in that timeline, sir. Okay, and on the back of this is the very image that she sent to you. Would that be correct?
Right.
And that's a fair and accurate depiction of that thumbnail, correct? And it's a fair and accurate depiction of what's up there in that timeline, correct?
I believe so, yes.
Okay. At this time, we ask permission to admit stage 378.
No objection.
And you talked about these, and I think you told us before on cross that these messages, they weren't hacked or anything like that from the police. These were the messages, right?
Right.
Okay. We're now going to publish 378. So this message, if you could, please tell me what is the time. Oh, it's kind of cut up a little bit. What time is that message sent?
At 10:36 a.m.
Okay, on September the 2nd, is that?
Correct.
Let me have this other little blurb. It doesn't actually have anything there, but what is the time on that?
10:36.
then we have on this following page another message at 3:16. Is that correct?
Mm-hmm.
I think she's kind of talking about how much, she's selling some cards and making some money, something like that, correct?
Right.
And you immediately kind of respond within a minute to her at around 3 o'clock, correct?
Right.
But you don't do anything here, correct? Because it's just a random message, and there's no need to, nothing's being asked of you, right?
Right.
It's just a random message,
Right.
and, you just take care of it when you walk in the door, right?
Pretty much.
Showing opposing counsel what's been marked as state proposed 379 through 387. Before I approach, I'm just going to ask you one more time. You didn't delete anything off your phone on September 2nd of 2022, did you, sir?
Not that I recall.
Now we're going to approach the state's proposed 379 through 387. Why don't we take a look at those?
Okay.
Okay. Sir, do those appear to be messages that we just looked at from maybe some other device that we were just looking at through your text messages or your timeline?
Yeah.
Do those appear to be fair and accurate depictions of those messages?
Except there's an additional message.
Right, there's an additional message. That's your wife's Apple Watch, isn't it?
It is.
Okay, and that's a fair and accurate depiction of what that watch looks like, correct?
I believe so, yeah.
And with the exception of the one message that's off, everything else seems to be a fair and accurate depiction of your communication on that day that you were just telling us about on the timeline. Isn't that right?
So it seems, yes.
Okay. At this time, we'd ask for the admission. State's proposed 379 through 387.
We could approach, please.
Okay, they're admitted into evidence.
Sir, you maintained that on the morning, September 2nd, 2022, you were at home, correct?
Right, except for when I went to take a walk.
You deny going over to 7216 Bronze Circle, correct?
Yes, sir.
Publishing 379. That is your wife's Apple Watch, correct?
I mean, it's got a picture of my daughter on it, so I'd have to assume that it is.
No. That's the same picture you just told us about from your text messages, isn't it?
Yes.
And it's at 10:35, correct?
Yes.
It says Friday, correct?
Yes.
It also says Rob up in the corner, correct?
Yes.
I'm now publishing 380. Please read to this jury, what does it say underneath that photograph?
It says, "Where are you?"
Where are you? You told us you were at home.
I did not. I said, actually, when I got the messages, I was still on my walk.
Sir, is it your testimony that you were at home on the day in that morning?
Not the entire morning, no, and
Okay.
I said that to you,
And let
sir.
me ask you this question. That message isn't on your phone, is it?
It isn't, I mean, if
No,
it was
it's not
sent,
on your-
if
it's
it
not
was
on
sent,
your
it
phone.
should have been,
One
but
at a time, one at a
Sir?
time, please.
Yes or no? That message isn't on your phone.
why it isn't, I wouldn't know, because it,
I didn't
apparently it's
ask
not.
you why.
It's not on my wife's phone either.
Sir, I didn't ask you why. I asked you a yes or no question. That message is not on your phone, correct?
From what you showed me, it is not.
And you were in possession of your phone on that day, correct?
On that day, yes.
And you, as the owner of the phone, have the ability to save messages and delete messages, correct?
Yes.
Because the person who holds the phone controls the information, correct?
At that moment, yes.
Right. And she's asking, where are you? Right?
Yes.
At that same time, at 10:30 in the morning, we've seen video surveillance of a car that you say looks just like mine driving in Mr. Gehrman's neighborhood, correct?
That is correct.
Sir, if you left your phone at home, you wouldn't have been able to respond to that message, correct? If you were not next to it, correct?
I think that's speculative, but you're
If you
saying
left
if,
your house and left your phone at home on the morning of September 2nd, and your wife's texting you, where are you? You wouldn't have been able to respond to that, correct?
but I did not.
I didn't ask you that. If you were not in your house on September 2nd in the morning, and your wife sent you a message with a phone you had left at home, it would have been impossible for you to answer that question, correct?
Again, it's a speculative answer.
He can answer.
But
I'll ask you again.
again, that would have been if in fact that was the case. If in fact I left my phone at home, then sure, yes.
I have no further questions for this witness.
Okay, so at this time, we need to end early today, so we're gonna conclude for the day. Can I get turns closed just so we can talk about tomorrow's start time?
All right, so everybody, excuse me there. While we're on this slight break here, while we're waiting for, it looks like the day has ended. We're going to be moving into day 8. But there's, you know, we're getting the jury out of the room, and then we're going to conclude for the day. Want to remind you, this is the Robert Paez trial. If you're just joining this, he is or he was a politician in Las Vegas, and he lost his position due to an expose from a reporter
We're going to start tomorrow morning at 9:30.
who worked for Las Vegas Review-Journal. This set off
Thank you very much for your time and attention. You are excused till tomorrow morning at 9:30.
between this man that you're seeing here on your screen, that resulted in, the state says, in him killing this man. He is saying that he was set up and framed by a corrupt Las Vegas government, who set out because of the influences of major multinational corporations that were involved in fraudulent schemes to try to essentially take advantage of individuals who didn't have wills and had estates that the local Las Vegas government, in fact, it was his position, that he was cracking down on these companies. He was attempting to make them, hold them accountable and have them investigated for their actions.
You do solemnly swear the testimony you're
Anyways,
asking this
we're back to
action shall be
testimony
the
here.
truth, the whole
So
truth,
day
and
8
nothing but
starts
the truth,
out with
so
a
help you
witness,
God?
and then
I do.
he will
Please
return to the
be
stand. Mr. Tejas does return to the stand.
Please state and spell your
But
first
anyways,
and last name for the
let's
record.
go back
Clifford,
here.
C-L-I-F-F-O-R-D.
continue on.
Last name is Mogg, M-O-G-G.
May I proceed? Thank you. Sir, I want to turn your attention to September 7th, 2022, probably about 9 o'clock in the morning. Do you remember where you were around that time?
I was at Mr. Tejas' house preparing to execute a search warrant at that location.
Did you have an opportunity to at least interact with Mr. Tellis' wife, May Ishmael? May?
I know her as Mary Anaya de Tejas.
Okay. On that day, do you end up taking a couple of photographs on that day?
I did.
Okay, what did you take a picture of?
So during the interview with Mary, I learned some information that I felt would be important to the investigation, namely a text.
Well, I don't want to get into the substance. Just did you take any photographs?
I had crime scene investigators take a photo.
Okay. I want to show you what's been already admitted. States 379 through 387. Are these those photographs that you had taken or directed to have taken?
They are.
Okay. Publishing 379.
So wanted to take a moment here, guys, to stop the testimony here. We have close to 70 people in the chat here. So I want to go over a couple things with you guys. Number one, hit that like button on your way out. This is the final day. This is the final presentation of the Bobby or Robert Tejas trial that just took place in Las Vegas. We have a full playlist on the channel. Link is in the chat. If you want to watch this trial from A to Z, they're fully curated, fully edited. Also, if you have any questions about the trial, any questions about what you see, any questions about things going on with what you're seeing on the screen, put them in the chat. Super chats will get priority. And also, just so you know, we're running a super drawing opportunity. You will get, we already have one entry so far, this chat or this stream. But all chats this week have been running this. Anyone who does a super chat $5 or more gets 2 entries to start out with, and every $2.50 over $5 gets an entry into our super drawing. You get a justice is a process, a commemorative exclusive hat that we will send to you, and we will make the announcement on our community page. So anyways, just want to throw that in there. Hit me up with questions. We will stop the stream for any super chats to come in and address them personally, and they will stay up on the screen for a few minutes, for up to 3 minutes, 3 to 5 minutes, unless there's multiple chats. So you got something you want heard, you got something you want seen, let us know. Anyways, let's get back to the trial, and we'll talk to you soon.
This is the first in that series of photographs, is that correct?
That's correct.
I have no further questions for this witness.
Yes. Thank you, Monk. Mr. Monk, may I see this?
Sure.
Turning your attention to State's Exhibit 379. You took a series of photographs, correct?
I had a series directed to be taken.
At your direction, a series of photographs were taken.
Correct.
And that would include various text messages that were alleged to have occurred between this phone and another phone, that phone belonging to Mr. Tellis.
Yes.
These were addressed yesterday through the course of Mr. Tellis, and it's funny, you have referred to him as Tellis. I've spoken to him as Tellis, but it's Tellis apparently as well, but the defendant in this case.
Okay.
And there was a line of questioning as to whether or not the communication between these two, when I say this is a phone, I mean this is an Apple Watch, correct?
That's correct.
And that there was a text message or an SMS message deleted, correct? Are you aware of that?
Deleted from...
On the part of Mr. Tellis's phone.
I'm going to object. I think that misstates the testimony, or at least the question posed.
You're asking if he did?
If he's aware of it, yes.
Okay, you can answer.
I was not privy to going through the download of Mr. Tellis's phone. I had heard that there was a text message deleted, but I had never seen it.
Okay, so what we have here is basically whenever you have SMS messaging, text messaging, it's generally how that's referred to. Obviously you have a phone or an electronic device that receives it. Let's say Mr. Tellis's phone, and then the phone that it's sent from, or the device that it's sent from, which is presumably this Apple wristwatch, correct?
That's correct.
Did you ever take the actual physical phone from Mr. Tellis and review whether or not these images actually appeared on his phone?
I did not do that. That was not part of the investigation that I was involved in.
So then we're confined to drawing a conclusion at this point in time that when you see a certain message on this device, the Apple wristwatch device, but then it doesn't appear on an extraction, and then an argument is made, well, it was deleted on his side. We're basically comparing the actual device, the Apple Watch, versus an extraction, correct?
Yes.
You familiar with Cellebrite extractions?
I am familiar with Cellebrite extractions, but that is not in my area of expertise.
Was there ever a discussion on your part concerning a timeline extraction concerning Mr. Tellis's phone?
I know what a timeline extraction is in Cellebrite and how to use them, but again, I didn't conduct the download of Mr. Tellis's phone, nor did I review the contents of the download.
If I were to show you from what's been provided from the state, the timeline extraction concerning Mr. Tellis's phone, would you recognize it?
I could try to look at it.
Let me approach the clerk and have these marked as exhibits. Let me approach the witness. And I'm approaching you with been marked as Defense Exhibit L3. And if I represent to you that this is the timeline extraction taken from Mr. Tellis's phone, would you have any reason to disagree with me?
No.
I'd move at this time for admission of Defense Exhibit T3.
No.
No, it's L3. just-
L3, I'm sorry. Permission to publish. I may approach the witness. Is there a light here that... I'm somewhat of a Luddite, but can everybody see that?
There is a light.
There we go, that's better. Here we have Cellbrite, it's the extraction report. To your knowledge, this extraction report was done by Mr., is it Hesefetch? Am I killing his last name?
Who?
He did we heard from him
Oh,
last week.
Detective Hovanek?
Hovanek, I'm pronunciation, Tellis, Tellis, Hovanek. This, you would agree with me, this timeline extraction, this is a more in-depth extraction. This is, obviously you can access through various portals information that's contained within the cell phone, correct?
Again, that's out of my field of expertise. I'm familiar with the Cellbrite extraction reports, and that's about the extent of it.
Here we have this column, deleted column. You see that?
Correct.
And we have a deleted column concerning a much earlier timestamp of 4/14/2020. I told you that has nothing to do with this case. Fair to say?
Correct.
And then we have this, and it says deleted. And then here we have these instant messages incoming, and we have times. 9/02/2022, 10:36:02. Correct?
That's correct.
And on the right column, unlike the first one, where we see deleted, the entry on this Cellbrite extraction does not contain the term deleted. Fair to say?
It doesn't contain the term yes.
And again, to your knowledge, and actually, yes, obviously we had you taking photographs of this electronic device, which was presumably on his wife's wrist. Fair to say?
It was.
But we don't have any photographs to be provided for you or the foundation laid concerning the photographs taken of Mr. Tellis's electronic device, his cell phone, correct?
I didn't have access to his cell phone, nor did I do the download extraction of his cell phone, and it's beyond my area of expertise to testify as to how the downloads are conducted, what would be deleted, how you would see it.
You're aware that a cell phone obviously was seized, and obviously it was analyzed by the Metro, the Las Vegas Metropolitan Police Department.
I'm aware of that.
And finally, it's fair to say that your primary responsibilities in this investigation concerned surveillance videos, ring cam videos, security videos, correct?
That was not my only primary job. That was one of them. I also interviewed Ms. Tellis, and I assisted in the execution of the search warrant at his house.
Did the Tellis home have a ring camera?
It did.
And did you collect or extract any information, any data that was on the ring camera?
I did not. I know our digital forensics detectives were at the execution of the search warrant. They would have done all of that work. That wouldn't have been anything that I would have been involved in.
Obviously, you would agree with me that the ring camera at the suspect's home would be significant to the investigation in this case, based upon your training, experience, your knowledge.
It would, but sometimes it captures things, sometimes it doesn't. Depends how long it is, it overwrites. It depends whether you have the service as to whether or not things are stored on the cloud, how long they're stored. So there's a lot of variables that go into a ring camera.
Thank you. I have no further questions.
Anything else from the state?
Just one question. There were some questions about the ring camera. Do you know when that camera, do you remember when those surveillance cameras were put up?
I believe Ms. Tellis told me that the camera on the front of the garage was put up or purchased somewhere around September 5th. But other than that, I don't know when the ring camera was put up.
Thank you.
Just so we're clear, we're not talking about the surveillance cameras you know, up above the garage. I'm talking about the Ring camera. You know the Ring cameras that a lot of people have that are at the front of the door?
That's what I was speaking of.
Okay, front of the door, then, you know, by the handle where you go in. You're talking about that camera? You didn't look
That's
at
the
that?
camera I was referring to when I answered your question, Mr. Draskevich.
Okay, thank you. I have no further questions.
Thank you very much for your, oh, do you have another?
No.
Okay. Thank you very much for your testimony here today. You may step down and you are excused. Thank you very much for coming back today.
Thank you, Your Honor.
And Mr. Tellis, you can retake the stand.
Can we have just a moment?
Okay, that's right. Okay, 1, 2, 3. Okay, we're going to take a recess. During this recess, you're admonished not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. Read, watch, or listen to any news or media accounts or commentary about the case. Do any research. Consult dictionaries, internet, or reference materials. Do any investigation, test a theory, recreate any aspect of the case, or in any other way investigate or learn about the case on your own, or form or express any opinion regarding the case until it's finally submitted to you, and we'll be in recess.
Thank you.
Okay.
All rise for entering jury, please, jurors. Everyone, please be seated.
Does the state stipulate to the purpose of the panel and the defense?
Yes.
Okay, would you please raise your right hand so you can be sworn by the clerk?
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated. Please state and spell your first and last name for the record.
Robert Tellis. First name is Robert, R-O-B-E-R-T. Last name T-E-L-L-E-S, also pronounced Tellis. Thank you. So, good morning. I want to go over some of the items that were discussed during my cross-examination by Mr. Hamner. So I'll start. I'm just going to go, point by point. So it sounds like I'm jumping around. I'm just hitting various things. So I want to talk about Zach Schilling first and why he was mad at me. But in order to do that, I've got to talk about the way that probate sales were done in my office at the time I was in leadership. So what we did was we went from, before I got there, from one realtor to a number of realtors. The prior public administrator, for some reason, had this relationship with this realtor, and he wanted to just have that guy do all the homes. There were a couple of problems with that. The first one was that oftentimes he couldn't handle the volume of renovations. And so oftentimes a lot of these homes would sit for months. Once in a while, they'd be in danger of foreclosure. But even if they weren't in danger of foreclosure, one of the issues that would occur was that these homes still had oftentimes mortgages going. Right? So if we weren't turning those homes around in 6 months, 9 months, a year, all that time, the mortgage was taking a chunk out of the equity. So I wanted to make sure that we were turning these things around faster so more money would be in the hands of the family. I didn't think that, having a sole vendor who would get to it when he got to it was of benefit to the families. The other thing was that, of course, Clark County has this policy of trying to support as many small businesses as they can. And so I was trying to also mirror that too by opening this up. I certainly didn't like the idea of having one vendor for anything. So what was important, though, for these vendors was that they had access to capital. That's why I didn't have a larger pool as of yet. I had probably, any given time, maybe 5 or 6, just depended. But they had to have access to capital so that they could perform the renovations on the home. And the reason for that was that I wanted to make sure that we gave the families as much money as possible. When you sell a home as is, when it's in disrepair, often it has to be sold for less. Right? And that gives flippers an opportunity to get the house, flip it, and then take the proceeds that would have gone to the family. Now, there's not necessarily anything wrong with that. I just wanted to put that money in the hands of the family instead. And in order to do that, we had this policy where, again, if you want our business, you had to go ahead and have the money to do the renovations on that house. You had to make it move-in ready. So any family could buy it and move right in. They wouldn't have to wait around for anybody else to do those renovations for them. And like I said, in the process, the families themselves got all the profit that might have gone to a flipper. Because of the capital demands of having to do this, 2 of our vendors had more properties than the others. One of them was Brian Horner, and the other was Bob McMaster. Now, as part of Bob McMaster's team, he had Zach Schilling. Bob was the capital man. He was very successful in his prior business. He was, I don't know the extent of his finances, but he didn't need to do the work. He was doing it really for the sake of keeping busy in retirement. But he was the money man, so he was the vendor, right? And Zach was the listing agent. I don't want to minimize what he did, but at the end of the day, those listings were going to that team because of Bob McMaster's capital. And in return for any of our vendors doing this work, instead of getting a 3% commission, they would get a 3.5% commission. And I got approval from the probate commissioner to pay our selling vendor 3.5% while still giving the buyer's agent 3%. So the total commission was 6.5%. And that was pretty much from the get-go during my administration. So at a certain point, for whatever reason, and again, both Brian and Bob were getting a good share of houses. And at some point, Zach decides that he is going to move his license from the broker where both he and Bob have hung their licenses. And he does it without telling Bob that he's going to do it. When Bob goes to move his license as well, the broker says, you cannot hang your license here unless you're going to have deals. Now, Bob enjoyed the renovation side, but obviously he still wanted to make a commission split for the work that he did. So he was not okay with not being able to hang his license, because you have to have, from what I understand, an active license hung somewhere in order to take that commission. So what he ended up doing was finding another real estate agent to assist him, to be the listing agent. Zach was very upset at Bob with this. And then it came to the point where when Zach asked me to give him a large number of houses, I couldn't, because he didn't have the access to the capital. When I would walk houses with him, he would try to minimize the importance of doing this renovation or that renovation, trying to just, again, minimize it so that he could try to get as many houses as he could without getting us what we needed to make these homes move-in ready. And so that wasn't acceptable to me. He still got homes, but he didn't get nearly as many homes as he did before. I think that's what upset him. beyond the fact that for some reason he was still hung up on that Ottawa thing that happened a year and a half before, which I don't know why that was a big deal for him, but he apparently mentioned it in his interview with the police that, you know, that he had that. So, all right. So then I want to move to the supposed electronic evidence that was allegedly found on my phone, or a phone image, or what have you. When I was arrested, the police leaked to the media that there was allegedly a shoe found in my house. There was allegedly a hat found in my house. They allegedly found the DNA. They did not leak that they allegedly found this electronic information on my phone or on some image, despite the fact that they allegedly had it at that point. So I can't explain why that was the case. Now, when it comes to these Google Maps shots, again, I'll reiterate that I did not know Mr. Gurman's address. So whoever plugged that in obviously did know the address. And there was a photo that we were shown that showed a video camera that was right across the way from Mr. Gurman's house. I do not engage in crime, but if I wanted to do something while not being caught on camera, and I knew there was a camera right across the way, I wouldn't do it. And which also brings up another point. If I knew there was a camera right across the way, I certainly would find another means of transportation besides using my own vehicle. Certainly, I wasn't rich, but I certainly, I did okay enough that I could rent a nondescript car, but I couldn't see myself as the kind of person who would be foolish enough to use my own vehicle to allegedly commit any kind of crime. And let's see here. So again, I did not know Mr. Gurman's address, so I don't know how anyone could say that I did these searches. And then I didn't know Mr. Gurman's schedule. I did not know Mr. Gurman's schedule to know that he would be home on that day at that particular time. Yet apparently the killer knew. I did not know the layout of Mr. Gurman's home, or what room he would be in, or what, I wouldn't know how to, as I said, lure Mr. Gurman out of his house. So, I didn't commit the murder. I don't know how the murderer knew that. I certainly did not. So the person who supposedly took these photos on August 15th, it seems knew that Mr. Gurman had a gray Honda from what we heard yesterday. Yet that same person, or allegedly I, decided to research Mr. Gurman's car anyway after the fact, when this person already knew that he had a gray Honda. That doesn't make any sense. And again, like I said, when you saw that the search term was for, again, Mr. Gurman's address to get to that information on the car, and I didn't know Mr. Gurman's address. Now, also, I did not buy a straw hat. I did not buy a construction shirt. I was fully investigated on my finances. I believe that if I had, that you would see evidence of that. When it came to the police search of my home, I was being detained at the police station. Now, I was not handcuffed. I was seemingly, I mean, because of the fact that I wasn't handcuffed during the entire interrogation, it would seem to me that the officers who, Gaddis and Jappy, who had me in that room, did not fear that I was a danger to them. So I was stuck in that room until the search was done. My wife was sequestered, along with my children, in a room during the search. She was under supervision by a police officer. And there was no body cam video from the search. I have seen numerous cases where body cam video was used during searches, yet it wasn't used during the search in my home. Then I want to speak to Detective Jappy's investigation. Again, Compass Realty had nearly 500 sales over the years, and Detective Jappy was investigating me for 5 months of alleged bribery. And again, the investigative file on me was 100 gigabytes for 5 months of alleged bribery, whereas for Compass Realty, over 500 sales around 500 sales for over years was only 3 gigabytes. Again, just a fraction of the information that was obtained on me in that investigation. And I guess, and you'll have to excuse me, but I'm going to have to, I guess, speak to that relationship that I had with Roberta. During COVID, we got in a position where, again, because of the way that staffing worked, we spent a lot of time together, and we grew close. And we grew too close. And, and obviously we have choices, and we made a big mistake. It's something that we both regret. But the thing is that, if Mr. Gurman had not been killed, you would not be hearing about the fact that it happened, that we actually got into that relationship. Mr. Gurman, as I mentioned before, was not going to have he was never going to get any information about what happened between us. The county had redacted, or I should say omitted, anything that might have been personal in nature. So the notion that this was a motive to kill Mr. Gurman was false. He was not going to have any real material to make a more damaging article than he would have already done. So that's, and again, Roberta is a good person, and she loves her family very much, just as I love my family, and we just made a stupid mistake, but that doesn't mean that I killed Mr. Gurman. So, and I would never engage in any criminal conduct because I respect the law. And I was trying to uphold the law in my position. Right? And certainly I would not commit a murder because I have respect for human life. I don't believe that anybody should have their life cut short at the hands of another person. And so when it came to Compass Realty, I was not a lame duck. When you watch that video from the June 29th, 2022 hearing, you'll see that I was not acting like a lame duck. And you will see that it was after the primary loss. And I still kept fighting. And you'll see during that video that I raised very serious concerns. And these are very serious concerns beyond, again, the issue with the equity and the personal property. These are other things that, again, if you could watch the video, see how the judge was concerned. And again, I had just gotten the authority to do the things that Detective Jappy did not do. And frankly, I believe the public should demand an FBI investigation into Compass Realty. I also have one other item related to Compass Realty. Now, Adam Fenn donated to D.A. Wolfson in March of 2022. And if you'll recall, at the beginning of March of 2022, D.A. Wolfson had introduced me to Detective Jappy. Now, when Detective Jappy informed me of the fact that he had found that there was likely theft here, I also found out that D.A. Wolfson knew as well. And I found out through my conversations with D.A. Wolfson. Mr. Horvath, in the topmost envelope, the first 11 pages, I have a copy of Mr. Wolfson's campaign report from the first quarter of 2022. I'd like to ask that I please be allowed to have it marked and published.
Mr. Hamner is the state by stipulation.
We'll submit it to the court.
Okay, if that is marked on
S3.
S3 will be admitted.
Okay. Would you like me to approach you?
Yes, please. Thank you. And so this is an excerpt of Mr. Wolfson's campaign contribution report, the first one of 2022, taken from the Nevada Secretary of State's website by public download. And it shows, and this is the fourth page, which again you're only going to receive the 4th page of this. It states that it's recorded that on March 26, 2022, Adam Fenn of 8782 Big Bluff Avenue, Las Vegas, Nevada 89148, gave Stephen Wolfson $5,000 for his campaign. I am not crazy. I am not trying to avoid responsibility. This entire situation, well, I'll put it this way, that Compass Realty could move so much with money in this day and age in our city is incredible to me. I'm innocent. And, you know, I'm not the kind of person who could brutally murder another man, do it with apparent experience and training, and then go to the gym, and then go pick up my children. Sir?
Have you concluded?
I have concluded.
Let me approach and get the, and we're moving for admission in case I believe it was already admitted. Thank you.
Is that all your redirect?
Yes, Your Honor.
Thank you very much. Any recross?
Yeah, briefly. How are you, sir?
I'm fine, sir. How are you?
I'm okay. I just really want to cover two topics. So, you touched on the public records request that, Gammon wouldn't have heard about any, personal communications between you and Roberta because the records request wouldn't allow it, correct?
That's correct.
Okay. And therefore, that's why you wouldn't try to kill him, correct?
It certainly wouldn't be a motive.
Okay. But you would agree with me, you're not friends with Mr. Gammon, correct?
No, sir.
He didn't tell you, sit down with you and tell you how he's writing his stories, correct?
He did not.
He didn't share with you what information he collected, correct?
He did not.
And you're familiar that, journalists have things called sources, right?
Sure.
And they collect information from multiple places, correct?
Sure.
Okay. So all you know is that Mr. Gammon had made one personal records request to your office, correct?
Correct.
You don't know what other information he had gathered as of August of 2022, correct?
That's correct.
Therefore, this idea that Gammon wasn't going to be able to write any further article, you don't know that for a fact, isn't that right?
Well, I certainly thought, based on the records request, that he would not.
Right, because you're claiming you base it on that limited knowledge, but let's be clear. Journalists have multiple sources that they can collect information from, right?
Sure.
And you knew that as of August 8th, he did intend to want to seek information about you and Roberta, correct?
Right.
You had even told your best employee, Nicole, that I have a fear that these articles are going to jeopardize my ability to have employment in the future, correct?
I did.
you were concerned about even being able to work as an attorney in the city. Isn't that right?
I thought it crossed my mind, yes.
Not just crossed your mind, you memorialized it in a private text message to your best employee, correct?
Mm-hmm.
And you additionally told her, I am, oh God, I wish I had it in front of me. Let me just see if I can recall this. You are worried about the article. Give me, you know what, can I have them pull off in the email? I don't want to get it wrong. Yes.
Court's indulgence.
Oh, I remember what I wanted to ask. Sorry. Thank you. Now I remember. You told this jury that you claimed you weren't worried when you received the August 8th email from the county that Cameron was looking into it because you weren't worried because you knew none of the personal stuff was going out, correct?
Yes.
But isn't it true just a couple hours later you're writing the call saying the exact opposite?
No.
Okay. You don't know it. We'll let everyone check the notes on that. But
Sure.
Isn't it true the message that you send to Nicole post-dates the email you received from the county?
Yes, but I was talking about pre-existing articles.
Sure.
And the damage that was done.
That's what you claim.
It's what I claim, yes.
Okay. So, you were so concerned about the articles, you're writing your best employee about it, correct?
I did not reach out to her to do it.
And then 4 days later, there's 130 images mapping out Mr. Cameron's neighborhood, correct?
Not for me, but yes.
And then on the 15th, there's this amateurish surveillance going on, correct?
Objection is characterization. Amateur.
I'm sorry. Well, I'll rephrase. There's the Popeye surveillance happening, correct?
Again, I didn't do it, but yes.
Okay. And then just after that, we have, as you fully admitted, there are pictures from your desk of all of Mr. Garman's personal identifying information in your phone, correct?
And I don't know that to be the case. Again, it could have been placed there on an image. It wasn't
Sure, but you
necessarily on my
fully
phone.
admitted, like, that's my computer, that's my desk. And you told us that yesterday, right?
The photo appears to have my desk, yes.
No. You said, that's my desk. You didn't say it appears, you said, that's my desk.
I thought it
Remember?
yesterday, but sure. Again,
Thank
same
you.
thing.
And that just happens to be the same month that your expert witness looked into your phone and saw you turned off all your location data.
I object not as to that month. It appeared most of the year
And-
that location was not there. So
Right,
that
right, and-
mischaracterizes Mr. Guerrero's testimony.
Sure. Isn't there a slide from August 1st to August 31st of 2022 talking about location data from your phone?
Yes,
And it was a blank slate, right?
and I will get to that in my redirect.
No, you got to get to it now. Isn't it
But,
true?
give
it
me
was a
one
blank
moment, please.
slate?
Can you give me one moment, just a second, right?
Just a minute, just a minute.
Please? And okay, so can you give me
Sir.
the question? Okay, hold on
Isn't
just a
it
moment,
tr-
please.
Isn't
Just one
it
moment,
true
please.
that there is a slide produced by your expert that's entitled August 1st through August 31st, 2022, and it literally says no location data. Do you remember that slide?
Yes, sir.
Okay, so that existed, correct?
I don't know that it did, because I didn't take that photo.
No, just your expert did.
Are we talking about the photo or the
Expert
slide?
did not take the photo. So
But
again,
was it prepared?
Right, your
Who prepared
expert, your expert introduced it on his direct examination. Do you remember that?
I don't know if you're talking about the slide or the photo, sir. I'm trying to get
I'm
clarification.
talking about the slide.
Okay.
Your expert analyzed your location data for the month of August. Do you remember him talking about that on direct?
I said that earlier, yes.
Do you remember him talking about it on cross?
I don't, but I remember him talking about it.
And you remember seeing the slide, and he showed an image showing that there is not 1 ounce of location data on your phone for the month before Mr. Garman is killed. Do you remember him saying that?
Yes, sir.
Thank you. And then the second point is, let's talk about the donation. So Adam Fenn donated $5,000 to Wolfson's campaign, correct?
Yes.
It came from a campaign report in the first quarter, is that correct?
Yes.
So that would be the first 3 months of the year, correct?
Yes.
So sometime between January to March is this $5,000 donation, correct? That's 2 months prior to the Gehrman articles, correct?
Correct.
Okay, so
And it's also
So
a
no-
few weeks after the introduction maybe between me and Wilson and Jappy.
So you say Compass could move so much money in this day and age, it's incredible to me, correct?
Right.
And what we've heard from you is it's a whopping $15,000.
So what I have found in doing my research on Mr. Wolfson's campaign reports is that he's got people who donate to him year over year.
Okay.
So basically it's a subscription for a get-out-of-jail-free card.
So now the DA's in on it too.
I'm just telling you what I found when I've researched, and you can look at the Nevada Secretary of State's website to do the research yourself.
Well, I've got you here, sir, so I want to ask you, is DA Stephen Wolfson in on the conspiracy to have Jeff Gehrman murdered? Is that what you're saying?
I don't know about that, but I certainly know he turned a blind eye toward crime.
So answer my question, yes or no?
I don't know.
Okay. So, but you can't rule it out, right?
Can you rule it out?
It doesn't matter whether I can rule it out. I'm not the one under oath.
I can't rule it out.
Okay, so you can't rule out Rita, you can't rule out Wolfson, you can't rule out Cliff Maugg, you can't rule out the DNA people, you can't rule out anonymous patrol officers. Am I catching this all right? You can't rule out Adam Fenn, anyone from Compass, right? How about Cindy Sauerland? Is she part of this too?
I don't know. I can't rule it out.
Okay, so it's all just one big conspiracy, correct?
No, sir, I didn't say that they were all involved. I just said I can't rule out who and who is not involved.
But at the end of the day, you're just the victim in this whole thing. Is that correct?
Yes.
Thank you. No further questions.
Okay. Anything else, Mr. Davis?
Yes, and again, when it comes to these photos and the notion that there was no location information on them, I didn't take the photos. So whether they had location information on them or not, I'm not surprised they don't have any location information on them. So this point that somehow that shows I'm guilty is just, I don't know, it still makes no sense to me. And then when it comes again to Mr. Wolfson, I did do that research into him, and I did find that around the time that Paris Hilton had picked up charges here in Las Vegas, that
Objection relevant.
I think he opened the door.
Objection is sustained.
All right. So I'm sure that someone will be doing the homework on that. But
And
I think
comment
that's,
is stricken from the record.
and so thank you, Your Honor. I have nothing further for myself.
Okay, anything else?
Based on that, no thank you.
Okay. Looks like we have a question from a juror. We have questions from a juror. Court's exhibit number 20. Were you concerned that your wife would get knowledge of the affair before you get to tell her about it yourself, or did she only find out after Mr. Gehrman's murder took place?
She actually did find out beforehand, and I did, unfortunately, like I said, I made a mistake, and it is what it is. And so, no, as far as my wife is concerned, and my family is concerned, they did forgive me for what happened.
Okay, in court's exhibit number 21. How tall are you without lifts?
5'6.5".
Any follow-up from any, do you have anything else you want to say, Mr. Tellis? Any follow-up?
I don't believe
based on
so,
those
yeah.
questions?
No.
Okay, Mr. Hamner?
No, you're
Okay, thank you very much for your testimony here today. And you may step down.
Thank you, Your Honor.
Are you going to have any further witnesses?
No, we are not.
Okay, so the defense rests?
That is correct, sir.
Okay. Does the state have any further witnesses in rebuttal?
Okay, what do you want to do? Okay, we'll call Matt Levin. Matt Levin.
And if you please remain standing, raise your right hand, face the clerk.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated. Please state and spell your first and last name for the record.
First name Matthew, Matthew. Last name Hovanes, Hovanec.
And before Mr. Hamner begins, we do have a quick question for Your Honor, just briefly. Your Honor.
Sir, I want to talk about, first, just briefly about an extraction report that you had an opportunity to review regarding a timeline, publishing 374. Do you see that here?
I do.
This is the one that kind of lays out text messages and phone calls that came in and out of Mr. Tellis' phone. Do you recall that?
I do.
Do you see how over here on the right we have a deleted column?
I do.
Are there instances where Cellebrite, its programming, can capture and notate when, for example, something is deleted? Is that right?
There are.
And what would show up in that column if the program was actually able to collect or catch that deleted data?
Usually there's a red X if it captures the deleted data.
Sometimes it may also say like a red yes or something like that.
Something along those lines.
Okay. In your experience, does Cellebrite capture every single time someone deletes data off their phone?
No.
Okay. And do you have an idea as to why that is? Like, why does it sometimes catch it, but sometimes it doesn't?
It all goes back to the inner workings of cell phones and how they store data.
Okay. Have you ever heard of the term like marked for deletion?
I have.
What does that mean?
So everything in a cell phone is stored in a database. When you press delete, say if it's an image, a text message, whatever it might be, while you, the user, no longer see that data because you believe you've deleted it, it could still be sitting in that database marked for deletion. So until it's overwritten or actually deleted from that database, it's not technically deleted from the phone.
Okay, and so there may be steps that a user of a phone could maybe take to make sure that it's not just marked, but like truly cleared out of a phone. Would that be fair? Or?
No, the user really doesn't have any access to the database.
So it's just the functioning of the phone,
yes.
Correct? Okay. And just to be clear here, I'm showing what are entries 23, 24, and 25. I'll zoom out just a little bit. So 23, 24, 25 don't have any marks for deletion, correct?
Correct.
Okay, so nothing's been noted there. But you did happen, I can't even remember, did you have a chance to see like the Apple Watch image?
I did.
Okay, to do a comparison, correct?
Yes.
You can't tell us whether or not definitively this, like, do you know if like it's deleted or not? Do you have an answer, a definitive answer on that?
I do not.
Okay, it's just simply, it's not here, correct?
Correct.
So a possibility is it could be deleted, it possibly, maybe it transfers over, it doesn't make it into the phone.
Correct.
Okay, and just to be clear, did you provide us with some information from Celebrite about deleted data?
I did a screenshot from their website.
Okay, I'm going to show opposing counsel produce any objections to its submission.
Just screenshot, no.
Okay, great. I'm going to publish, can we request, right. It's been marked, I haven't asked. Permission to admit the state's proposed 411.
No, Your Honor.
It's admitted and you get published?
I'm sorry, Judge, that was 411?
Yes. Sir, why don't you do this, if you can. Why don't you just read out from the header, just read it all for us.
Starting with deleted data.
Yeah.
Deleted data, mobile device forensics. Deleted data may sometimes be recoverable depending on the level of extraction obtained. The encryption type on the device will determine probability of success. Full disk encryption, file-based encryption, no encryption. Deleted data may be available in the following circumstances. It is not actually deleted, just marked for deletion, any extraction type.
Okay. Another topic. Recipes. Were you asked to search through Mr. Tellis' phone to see if there was any evidence of recipes located in the phone?
I was.
Okay. I'm showing opposing counsel what's been marked as states proposed 399, 400, 401. I'm going to show at least those right now to opposing counsel. I usually previously show, but I'll see them. All right. Okay. May I approach the witness? I'm going to show you states proposed 399, 400, and 401. Take a look at those and let me know if you recognize what you're looking at.
Yes. Search is conducted.
Thanks. Are these fair and accurate depictions of data that you reviewed and ultimately was extracted out of Mr. Tellis?
Yes.
We're going to ask that states proposed 399, 400, and 401 be admitted.
No objection.
So, in Celebrite, is there a search box that can globally search everything in a phone?
There is.
I'm actually going to show opposing counsel 398. May I approach? I'm showing with states proposed 398. What are we looking at here?
It's basically the home page from a cell phone extraction on Celebrite.
Okay, is this a fair and accurate depiction
It is.
of that? Okay. We're going to ask the admission of states 398.
No objection.
It's admitted.
And additionally, I'd like to approach opposing counsel with states proposed 402 and 403. May I approach? Thank you. Approaching the witness with stage proposed 402 and 403. Do you recognize what we're looking at here?
I do.
Are these, what are these?
Extraction reports of text messages.
Okay, and this is in relation to searching for fried rice?
Yes,
Okay. Are they fair and accurate depictions of some of the results that you had?
they are.
All right, we're asking for the admission of states 402 and 403.
No objection.
Okay, so I want to start at least with 398. What are we kind of looking at here, just so we can see?
Again, that's the main homepage of when you process something in Celebrite Physical Analyzer.
Okay, so this is kind of like the main home screen of Celebrite, correct?
Yes.
I see that your name is here. Is that right?
Correct?
Okay, and it's kind of giving the breakdown of what type of phone it is that right?
Correct.
Over here in this corner, what is that little box? And it's been cut off. In this corner up here, what is that little box?
That's a search bar.
Does that globally search every single category, every inch of that phone if you put in a certain keyword?
It searches all the parse data, yes.
Okay, so I want to first talk about the word recipe. Did you type that word in that global search box?
I did.
Did it produce some types of results?
It did.
Okay. Did one of them involve web history?
I believe it did.
Publishing 399. If we look at entry number 1, how many results were there total?
3.
What's the title of result number 1?
Air fryer French fries recipe, love and lemons.
Okay, so not chicken fried rice.
No.
What's the date that appeared in the phone?
September 1st, 2022 at 6:07 and 51 seconds p.m.
So not later in the week of that first week in September, correct?
No.
Let's look at the second entry. What's the title of that one?
How to make cauliflower rice, Cookie and Kate.
Okay, so not chicken fried rice.
No.
What's the date on that one?
August 29th, 2022, 7:04, 52 seconds p.m.
So not a couple of days after Mr. Gehrman was killed.
No.
Let's look at the last recipe. What's the title of that one?
French basil pesto recipe.
Okay, and what's the date on that one?
August 11th, 2022, 7:53, 45 seconds p.m.
So not a couple of days after Mr. Gehrman's murder.
No.
And if we look at that second entry, you described it. It said how to make cauliflower rice, but the word recipe doesn't appear there. Can you look at the second column?
Yes.
What is the website that was used for that?
Is
Read that out.
cookieandkate.com/cauliflower rice recipe.
All right, so the word recipe ends up appearing there, and that's how the Celebrite pulled it, correct?
Yes.
All right. When you did the recipe search, did you also find some instant messages with the word recipe in it?
I did.
Okay. Publishing 401. If we could, please read us the date of when this message is done.
August 24th, 2017, 1:47, 37 seconds p.m.
Okay, and in that second sentence or third sentence beginning there, can you just read that out? It's in the second row.
There you can find and post recipes and videos, learn about ingredients and techniques, ask questions, and share your love of cooking and food, writing with other community members.
Okay. Publishing 400. How many? This appears to be kind of instant messages derived between someone by name May and the defendant's phone, correct?
Correct.
So let's look at this first entry. What's the date on that one?
October 1st, 2020, 2:06, 36 seconds p.m.
And this deals with dog food recipes, is that right?
It appears to be.
Let's look at the second text message. What's the date on this one?
October 1st, 2020, 2:06, 36 seconds p.m.
So dog food recipes again?
Yes.
Looking at this date, what's the date on this one?
June 4th, 2021, 2:57, 21 seconds p.m.
Okay, so again, we're not even within the same year as the day that Mr. Gehrman dies, correct?
We are not.
Let alone a couple days afterwards.
Correct.
and this was, so that's that date. Okay, let's move on to the fourth one. What's the date on this one?
June 4th, 2021, 2:57:21 seconds p.m.
All right, so when you did a global search for the word recipe, this is all you could come up with out of that phone, or at least that's all that Celebrite came up with. Is that right?
Correct.
Did you also put in the global search box the terms fried rice?
Yes.
Publishing 402. What is the date on this instant message?
March 16th, 2022, 6:57:34 seconds p.m.
Okay, and what does it say in the message?
Can I get a bowl with teriyaki chicken and fried rice and a side of chow mein?
This appears to be potentially some people with the last name, maybe his children and Mr. Tellis.
Yes.
Turning to the second entry. What's the date on this one?
March 16th, 2022, 6:57:34 seconds p.m.
So again, not even remotely close to the month of September. Is that right?
Correct.
Could you please read out what it says?
Can I get a bowl with teriyaki chicken and fried rice and a side of chow mein?
Publishing 403. What is the date on this one?
That'd be March 10th, 2019, 10:08:44 seconds p.m.
Please read out the message.
Fried rice, chow mein spelled incorrectly, lemonade, and teriyaki chicken.
Okay, so this was all that Celebrite could draw up from for fried rice. Is that right?
That's correct.
Additionally, did you also run a search for the term Chinese rice?
We did.
This is focusing very well. Okay, and what happened when you typed that in?
No results.
Okay, so there was nothing that popped up.
Correct.
All right, thank you. No further questions.
Ross?
Yes, Your Honor, I understand that there will be another detective called after this witness. Could we have him stay for a potential recall?
Sure.
Thank you.
Sure. So you don't have questions now, but you
I
want me
do.
to...
Actually, there's a few things that we'd like to address right now. Your Honor, if I may approach the witness. Show me what's proposed at this defense exhibit N3. Could be a property impound report.
It does.
Reference to electronic devices.
It does.
I move for admission of defense exhibit N3. No objection. If I may publish. In reference to what may have been Googled, what may have been searched for or not, we do have a list of electronic devices that were seized as part of this investigation. Fair enough?
Fair enough.
And in addition to this, the Dell Optiplex desktop, at the bottom we have the Dell Optiplex desktop that you basically addressed last week through the course of your testimony. Do you recall that?
I do.
We also have another electronic device, the Samsung tablet in black case, correct?
Correct.
These questions that you were, and then again here we have Dell laptop, correct?
Correct.
In reference to these questions for recipes and the like, these questions, and based upon the Celebrate extraction, were based upon searches that may have occurred on the phone that was possessed by Mr. Tellis, correct?
That's correct.
Did you make these same searches on these other electronic devices?
I did not.
Looking for these recipes or anything like this on these other electronic devices that may have contained that information?
I was not.
I'm going to approach you with 3 exhibits. If you just give me just one moment. Let me approach the witness. Approaching you with defense proposed exhibits O, R, and Q.
That's O3R. Q3?
That's correct. You recognize these?
I recognize, what they appear to be, yes.
And you can tell the jury what they are.
2 of them are examination reports from Magnet's Axiom program. One of them is an extraction report from the cellular phone using Celebrate.
And these reports were prepared by yourself? Can you briefly approach?
Right. I mean, is there any further questions from for this witness other than that?
Before the lunch break, no, Your Honor, in reference to.
Okay. Anything else from the state? Okay. I'm going to ask you to step down. You're not excused yet. You're going to be called back. But I think the district attorney just has further instructions for you, and then we'll have you come back and continue with your testimony. Any other witnesses?
We can call. We can call Detective Gaddis.
Perfect.
Sorry, Mr. Question.
Mr. Hamner,
Detective
are you
Gaddis.
going to go?
Well, we need to talk to him.
Okay, just ask the detective to stay close by for further instructions. Mr. Draskovich, before the next witness comes in, do you want to talk to that detective?
Yes, thank you.
No? We'll wait.
All right, thank you.
I'm going to have him do because he hasn't announced. Okay, just wait. Thank you, though.
Is she up there?
Yeah, they said they.
Oh, okay.
I need to
No
set up
problem.
for, sorry. Sam, you want to give me that exhibit for that drive? You're gonna have to instruct.
Are we ready for detective?
I can start for the computer if that's okay with the court.
Sure.
Okay, so Detective Gaddis.
Okay, Detective Gaddis, we're ready now.
Please remain standing. Raise your right hand, face forward.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You may be seated.
Thank you. Good morning.
Please state and spell your first and last name for the record.
It's Justine, Justine, Gaddis, Gatus.
May I proceed, Your Honor?
Detective Gaddis, in the course of the investigation into the murder of Mr. Veerman, did you learn how many vehicles Mr. Tellis had in his household?
Yes, there were 3.
And can you tell the members of the jury what those 3 were?
There was the 07 red GMC Yukon Denali. There was a brown, I can't remember the model of it, but it was a BMW SUV and a black Tesla.
Okay, and we've seen pictures, obviously, of the Yukon and of the car stop with the Tesla, and I think there's some search warrant photos of the BMW. In the course of your investigation, did you become, his residence is on Spanish Steps, correct?
Yes, ma'am.
In the course of the investigation, did you learn about a Planet Fitness located on Charleston?
Yes, I did.
And did you ever drive or try to figure out the drive time between those 2 locations?
Yes, I did.
And what is it?
It's about 4 to 6 minutes.
Okay.
Depends on which street you take specifically or if you get caught at the light.
Okay. So if you were leaving Spanish Steps and going to Planet Fitness, you said it would take about 4 to 6 minutes?
Yes, ma'am.
May I approach, Your Honor? Sure. Detective, I'm showing you what's been marked as states proposed 407 through 410. If you could just look through those and let me know when you're done.
Yes, ma'am.
Do you recognize those exhibits as a map of those 2 locations, Planet Fitness and Spanish Steps, as well as pictures of Mr. Tellis' BMW?
Yes, I do.
State moves to admit 407 through 410.
No objection.
May I publish, Your Honor? I'm putting on the overhead on what's been admitted as states 407. Detective, what are we looking at in that photo?
That is a Google Earth image of the area of town that encompasses 9624 Spanish Steps Lane and the Planet Fitness over there at Charleston and Fort Apache.
Okay, and on the left side, there's a couple different routes you can go. Is that fair?
Yes, ma'am.
When you look at this, can you put the mouse or show the members of the jury the location of Mr. Tellis' house?
That's right there.
Okay. How about that elementary that we hear about?
It's this structure here.
Okay. And then are you able to move the mouse to the Planet Fitness location?
Yes, that is over here.
Okay. And that street, that main street up towards the top of the photo, that's Charleston.
Correct, ma'am.
Okay.
Yes, ma'am.
The street that goes in front of that elementary school, do we know what that street's called?
Red Hills.
Okay. I'm putting on the overhead now what's been admitted as states 408. What are we looking at there?
That is the picture of the brown BMW SUV that Mr. Tellis has registered to his family.
And this is 409.
That is the backside view of the same vehicle.
And states 410.
And that is a side profile of the same vehicle.
Okay. Now, the video that we've seen throughout the trial has all been little clips. But for all the video that was collected in this case, was there hours and hours collected from all of these locations?
Yes.
And that was all preserved by yourself and other detectives?
That's correct.
And for the record, Your Honor, all of the long-form video is on state's proposed 372, so we would move that into evidence or offer it.
No objection.
Okay. Now, with regard to this BMW, did you review video from Piggott Elementary School at a particular date and time?
Yes, I did.
And can you tell the members of the jury what that was?
So I reviewed it for September 2nd, 2022. Basically, at the time that the Denali arrives back on Red Hills Road and then up toward, as it turns towards Mr. Tellis' house, I continued to watch it as well. About approximately 12 minutes later, the vehicle that I believe is the brown BMW comes out of the same area, off the same street, and makes another turn down Red Hills Road, as if coming the same direction that the Denali had just arrived from.
And so, if I'm understanding you, the Denali comes into the neighborhood,
Yes, ma'am?
and then about 10 minutes later, or
I thought it was about 12 minutes.
12
but,
minutes later, you see a vehicle that you believe is the BMW go in front of that elementary school in the direction, one of the ways, to Planet Fitness?
Yes, ma'am.
Okay. And the state, Your Honor, would now offer 406, which should be a clip of that.
No objection.
It's admitted.
Can you cue over?
And are we seeing the vehicle take a left turn on that Red Hills Drive?
Yes, ma'am.
And the time at the bottom was 12:03?
That's correct.
Thank you very much. I'll pass the witness.
Cross-examination?
Yes, thank you. You've given testimony that the clip of video that we just saw was taken from the entrance of the neighborhood. Where specifically was this video that we just saw taken from?
It was the camera was affixed to the Piggott Elementary School.
Piggott.
Yes, ma'am. Yes, sir.
So it wasn't necessarily the entrance to Mr. Tellis's neighborhood, but I mean, it's a couple streets back, fair to say.
I guess we'd have to look at the map to be specific, but it's...
And that was addressed in Mr. Mogg's testimony and the location of Piggott in relation to the neighborhood where Mr. Tellis lives. But, I mean, it wasn't right at the entrance. There was a street that one had to drive up and come around and enter, fair to say.
Yes, it's a fairly short distance, though.
Fairly short distance.
Yeah.
Are you aware, in reference to the neighborhood where Mr. Tellis lives, are there other entrances and exits?
Yes, there is one additional that I know of.
Okay. Showing what's been marked as defense exhibit T3. Okay. Can I represent to you that this is a Google map between two different locations? I don't believe there's an objection to the commission.
No. Is there any objection to?
No, Your Honor, sorry.
Okay, T3 is admitted.
This is also a Google map.
Yeah, I'm just trying to figure out where that is. Okay.
Do you recognize these 2 points of interest?
Yes, I do.
I may publish.
Mm-hmm.
This little different subject, but we've got you here, so we're going to ask you this question. This is a Google map again, timed distances, the driving. We have this point here, the red point, the Clark County Public Administrator Office, correct?
Yes, sir.
And that is where Mr. Tellis was working.
Correct.
We've heard testimony concerning the search. I think it was from you on September 8th, 2022.
Yes,
correct?
sir.
And this other address on West Vegas Drive, North Jones Boulevard, this is the location that you were able to ascertain from photographs, and you had given testimony that you felt that this was a surveillance point. Remember all the photographs of all
Yes.
the various cars? That's that point, correct?
Yes, sir.
And we have a drive time, there's two, and oftentimes these Google Maps, they have different times, but we have 11 minutes and 12 minutes, correct?
Yes, sir.
We have a 4.4 mile distance and a 5.2 mile distance.
Correct.
Of course, indulgence for just one moment. Thank you, ma'am. I have no further questions.
Can you redirect?
No, Your Honor, thank you.
Actually, I do.
That's
I'm
okay,
so
go
sorry.
ahead.
Obviously, you were the primary in this case.
Yes, sir.
For the homicide detail. There had been testimony concerning these various locations where images were captured, security, ring cam footage, correct?
Correct.
By yourself and others.
Yes, sir.
Specifically concerning Mr. Tellis's home. There had been a discussion with Mr. Mogg concerning his security cameras, and I think you and I had addressed that last.
I know I saw the images of the cameras up and the cameras not up. And
Yes, exactly.
Yeah.
There was a question. There were security cameras up above near the roof line where they were not there on September 1st, but then later, I think Tolliver had testified, but then there were security cameras up above, correct? That
Yes.
had been later installed. And Mr. Tellis had testified concerning that. But let's talk about a ring camera.
Yes, sir.
A ring camera right by the front door. There was a ring camera there, correct?
Yes, there was.
And was the data from that ring camera obtained?
What was available was obtained, yes.
And what was available?
Oh, I'd have to look back in the case file. I don't remember at this point. I knew there wasn't anything at the particular timing that were basically on the 2nd. There wasn't much video that was found to be relevant.
Okay, so is it your testimony that there was no relevance? And I mean, obviously, did you have a chance to review what may have been captured?
Yeah, the ring video I did.
Okay, and specifically on September 2nd, was there any evidence that you're aware that was recovered from the ring camera that was right next to his front door?
I can't remember if there were clips from the 2nd or not. I just remember that whatever was there, I could tell it wasn't relevant. And that's why there wasn't any clips preserved, or they were all preserved, my mistake. But that's why any clips weren't used potentially in that video synopsis that was provided.
And who would have reviewed the evidence that was taken from the ring camera?
I know I did. I'm not sure who, are you referring to Detective Mogg?
Yes, or yourself. I'm asking who would have reviewed the contents of that ring camera?
I did, and I know he had it available to him with the video production, so I could assume one way or the other, but I can't say if he did. I know I did.
Okay, and if he had given testimony when asked that same question, he talked about the security cameras up above that were installed later, but he didn't appear to have any memory of anything that may have been reviewed from that ring camera.
Okay.
All right, and you don't have an independent recollection of what may or may not have been recovered from that ring camera?
I don't, I'm sorry.
Okay, no further questions. Thank you, ma'am.
Thank you.
Anything to add?
Yes. When you say not relevant on the ring camera, what does that mean?
We knew what time, or had estimated the timing of when the red denali would have left, when it would have arrived back. And there was nothing at those timing marks or really in between that time either showing that Mr. Tellis was home or that anybody else was coming and going.
So it wasn't informative as to the whereabouts of Mr. Tellis at any time?
Correct.
Thank you.
And when we talk about any time, we're talking later in the day?
I'm talking on the 2nd.
On the 2nd. So outside of that, you have no memory of anything that may or may not have been captured on that ring camera on the September 2nd?
I don't. I'm sorry, sir.
Thank you. No further questions.
Anything else?
No, Your Honor.
Okay. Thank you very much for your testimony here today. You may step down, and you are excused from your subpoena. Thank you for coming back today. Does the state have any further witnesses waiting?
We do not. Your Honor, I think we may be recalling, or Mr. Jaskovich may want to recall Detective Fulton.
Okay, all right, so we'll break for lunch.
Thank you.
During this recess, you're admonished not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. Read, watch, or listen to any news or media accounts or commentary about the case. Do any research, consult dictionaries, the internet, or reference materials. Do any investigation, test a theory, recreate any aspect of the case, or in any other way investigate or learn about the case on your own, or form or express any opinion regarding the case until it's finally submitted to you. I think that's our last witness of the day, right? We will bring you back in when that witness is here, and we will probably end early for the day. But at this time, you're excused for lunch. Thank you.
Thank you. All right.
state stipulate to the presence of the panel?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
Okay, we can bring the witness back in. Detective, you understand you are still under oath?
I do.
Okay, thank you. You can have a seat. If you'll just state and spell your name for the record.
Once again, first name is Matthew, M-A-T-T-H-E-W. Last name Hovanes, H-O-V-A-N-E-C.
Thank you.
If I may approach.
You may.
Detective, I'm showing you it's been admitted as defense exhibit L3.
Yes.
Showing you it's been marked as defense proposed exhibit 03. On 03, I'm sorry. It's been marked for admittance on Q3 as well as R3. And this time we can move for admittance of these. Objection.
Okay, they're all admitted.
Just have a couple questions for you.
Yes.
In reference to exhibit 03, you can see that this, on page 1, that this is an extraction report from a virtual image produced by you. I mean, you're forensic examiner, correct? In this, and you testified previously in this case.
Not sure what you're referring to as virtual image.
The photographs. We recall the photographs.
Oh, I
concerning
might be
Popeyes.
looking. You said 03?
Let me ask you this. I'll just back up. This is a report generated from the Dell Optiplex.
These are two reports here that were generated from data that I extracted from the Dell Optiplex, yes.
You can see that it was logged into with a personal Gmail account, correct? That would be page 4. rrtellis@gmail.com.
There has been a Chrome login with that email address, yes.
This was the same account used on the Android phone that you had given testimony to or concerning previously.
If I had that extraction, I could verify that, but I don't have any reason to not believe you.
Okay, and that's consistent with your prior testimony concerning the cell phone.
Okay.
Is it fair to say that that means that anybody, and we have a work computer and then we have the cell phone. Is it fair to say that this means that anyone in or out of the public administrator's office with access to this computer could also access the same Google account that the phone was syncing to?
I'm not sure I understand that question.
I mean, they're synced. And if a person, obviously, the Google account that the cell phone had access to, it was accessed also from the work computer, or able to, the one that was recovered from the public administrator's office.
I have nothing in this report to show me his phone was synced. I just have an artifact here showing me a Chrome login using a specific email address.
Okay. And if I told you that's the same login address that was used from the cell phone, would you have any reason to disagree with?
No.
And again, not claiming, you were asked previously about hacker information, but if you have this access from the public administrator's office, from the desktop, accessing the Google account that the cell phone had access to, it's fair to say that one could access that Google account from either location, from the cell phone or the desktop that was at the public administrator's office.
It would be possible to log into the account from both locations.
If I could turn your attention to Q3. You recall that line of questioning previously and the previous day that you had testified concerning all the images?
I do.
The alleged surveillance images?
Yes.
This shows, and if I represented you, this was the last snapshot being taken. It was on 8/15/2022 at 10:32:48 a.m.
That is what it's showing as a modified time. That's not necessarily the time the picture was taken.
Do you have any information concerning what the last access, and the last access doesn't necessarily mean that it was changed in any way, but that's what we, based upon your testimony previously, that's about the time that this was taken or it was accessed.
So on here, it has a modified timestamp. That's the last time that the phone interacted with that photo. It really doesn't have anything to do necessarily with when that photo was taken.
Okay. If I could turn your attention to what's been admitted, R3. If you could turn to page 18. Here we have there's a record of time of somebody accessing the Ariana Payne's employment probation completion. Do you see that?
I do.
And do you see that time being accessed at 10:44:29 a.m.?
I do.
Presumably that was from the desktop from the public administrator's office as well as the time that was accessed, correct?
That appears correct.
And if we could go to page 11. See that? You can see that as you can see, the first access is at 10:43:13 a.m., correct?
First visited date, time, yes.
In reference to the questions concerning deleted images, if I may approach. You were asked questions concerning the Celebrite extraction of the subject cell phone, the one belonging to Mr. Tellis. Do you recall that?
Yes.
Again, during the break, you didn't examine the actual cell phone, correct?
No.
You had been provided a photograph. It was a picture taken. It was up from the Celebrite webpage, and it discussed deletion, correct?
Correct.
Would that deletion necessarily concern the content, or would that deletion concern the metadata, or both?
It could vary. Could be both.
So the metadata is basically the data concerning the data on the phone. Is that a fair?
It's data about data, yes.
And in reference to this exhibit, it was the timeline extraction, correct?
Correct.
And if you could please explain to the jury what a timeline extraction is versus an SMS or a text message extraction.
So a timeline extraction basically takes all the artifacts that were parsed out by Celebrite and just puts them in a chronological order by date and time.
And you're obviously able to access various information through this timeline extraction.
I'm not sure what you're asking there.
This timeline extraction, it contains more information, different information than, let's say, the Teams or SMS extraction. Fair to say?
Not necessarily the timeline. It's just putting everything into order by date and time.
And there's an extra column on this timeline extraction contained within this exhibit L3, where on the right, and you did see this, correct?
Yes.
It says deleted, and it says yes, correct?
I'd have to see that again.
Absolutely.
That is correct.
So here in this right column, and it's, let's see, everybody see that? up here we have deleted, and it says yes, correct?
Yes.
And there were a number of questions made yesterday concerning a message that was sent to Mr. Tellis' phone. Message being 103602. And there was questions posed to Mr. Tellis concerning having deleted that text message. All right?
Okay.
I'm just telling you what testimony was today. Based upon this timeline extraction, where when a matter is deleted, it says yes. Here, we don't have the red letter stating deleted yes, correct?
Correct.
Same thing as to 3, the instant messages, deleted. We don't have yes, correct?
That's correct.
Thank you. I have no further questions.
Mr. Hampton?
Just want to cover quick topics. Publishing N through defense N3. You remember those questions on cross-examination? You were shown this property report and you were asked if you had searched for recipes in any of these devices. Do you remember that?
I remember being asked questions about the other devices, yes.
Okay, so if you could, sir, do you see where it says remarks here?
Yes.
Can you read that sentence for me?
Item 1 was taken from Lee Kinnett's cubicle. Items 2 through 6 were taken from Tellis' office.
Okay, so these were objects. You didn't search for the term recipe or fried rice in relation to digital devices removed physically out of the public administrator's office.
I've done no searches on the other devices.
So like you didn't go through desktop computers to look for recipes?
No.
Okay, but all of that stuff came physically out of the PA's office?
Yes.
It didn't come out of Mr. Tellis' home?
No.
Do you remember there being some question about whether if you have a login that connects to an email, that somehow that links a phone to a computer, something along with, do you remember that?
Yes.
Okay. Just to be clear, you said that that's not what that necessarily means, correct? That's not what that stands for?
That's correct.
Okay. And just to be clear, there are apps or softwares or programs that sometimes require an email address as your username, right?
That's correct.
It doesn't necessarily mean that the data will show up on another device. It just means if you want to access that particular website, you could, you type in your email and then maybe a password or something like that.
Correct.
Okay. And on those documents, it appears Mr. Tellis' Gmail account is maybe the username.
It does.
There was questions about, I think there was one of those street surveillance images. There was a report on that.
Yes.
Okay. Just so we're clear, you on direct and I think on cross talked a little bit about the difference between when the report says modified versus created, right? You've
Yes.
had discussions with this jury about that. What is the difference if you see in an extraction report where an image is created versus modified? What's the difference?
So when the image actually has a full complement of metadata, you might get something like the created time when that picture was actually taken, when it was created. In this instance, with the modified time, that's the last time that that phone interacted with that file for whatever reason.
And I think we had a lot of discussions about the pathway of a lot of these images being located in what, a cache file, is that right?
Cache files, yes.
What exactly, again, is a cache file?
The cache file is just storing data about these files in order to help the phone speed up processes later on.
So you could, in theory, create a photo, delete that photo that would have had the creation metadata, but if the image was stored in a cache file, that image would just still stay in there, correct?
It would.
Okay, and so when we're seeing modified, you said that's the last time your phone is interacting with the image in the cache, right?
Yes.
And again, the phone has this cache file because it does what? Does it shrink sometimes images down so they're easier to send or things like that?
It can change the size of them just to make it easier to recall that image later.
Okay, but that's the significance of modified, right?
Yes.
There were some questions again about the where are you message. Do you remember being asked that on cross?
Yes.
just to be clear, you can't speak to definitively if it's been deleted or not. Isn't that correct?
That is correct.
And just to be clear, I'm going to publish L3, defense L3. In some instances, when there's this column here that says deleted, some instances Celebrite can actually capture when a user deletes an image, correct?
Delete some message in this case, yes.
And that's kind of what records that, correct?
Yes.
But there are instances where things are removed from a phone and it won't pop up in that column. Is that right?
Correct.
And I think you even had the little printout from Celebrite that explains that as well, correct?
Correct.
There were some questions about the distinction between timeline and Teams messages or SMS messages. Do you remember that?
I do.
Just to be clear, if a phone contained SMS messages, and maybe, you know what Microsoft Teams is?
I do.
Okay, let's just say for a second, a phone carried Microsoft Teams messages rather than, let's say, a desktop. But let's say the phone has Microsoft Teams message, SMS message, maybe multimedia message. If all of those categories were in a phone, and you went to the timeline, if it had timestamps on those messages in all those categories, would timeline just simply put it all in chron order?
It would.
Does timeline in any way manipulate or change the data that's in the phone?
No.
It just puts it in chronological order?
Yes.
I have no further questions.
Anything else, Mr. Dresser?
Yes, just so we're clear then, in reference to the images, and there has been testimony elicited concerning these images and your Popeyes, based upon your testimony, we can't say when those photographs were taken.
I cannot.
So then to say that they were taken in August, we can't really say that, can we?
I cannot.
So if there was a line of questioning elicited from witnesses yesterday that they were taken August 15th, we can't say that, can we?
I cannot.
In reference to the messages, and there's been questions asked previously concerning deleted or not, that perhaps Mr. Tellis had deleted this message from a family member on the morning of September 2nd. We can't say then, based upon your review of the data, if they, in fact, that question or that email had been, or text had been deleted, correct?
No, I cannot say that.
So it would be wrong to then assume that it had been deleted since we don't know.
On my end, yes.
And finally, I was asking if we could get, I have the things, but I'm not sure where it is. If we search it. There were multiple devices seized from Mr. Tellis's home, correct? Electronic devices.
You said from his home?
Yes.
Correct.
We had a Lenovo laptop, model 80SA. You aware of that?
If it's on the property report, yes.
We have a Dell laptop.
Sounds there were quite a few items seized.
And there were quite a few electronic items seized, correct?
Yes.
There was this Toshiba disk drive, card adapter, but we have at least 2 laptops, correct?
You say it's correct off the property sheet, yes.
Did you search those to look for the rice recipes or chicken and rice recipes concerning the questions that you were asked before?
I have not searched any other devices, no.
You did not?
I did not.
Thank you. I have no further questions.
Anything else from the state?
One question based off of something you mentioned. He said, remember that question, it'd be wrong to assume that like the where are you message was deleted by Mr. Tellis. Do you remember something along those lines? But just to be clear, even though you can't definitively say it, you can't rule it out as a possibility, correct? It's possible a user could have deleted the message.
That is correct. I can't say one way or the other.
Okay, thank you. No further questions.
But then to argue that it has been deleted, that would also be incorrect, correct?
Again, I can't say one way.
Right, argue is different. I mean, if you want to ask him his opinion.
You can't say.
I cannot say.
And we wouldn't be able to say unless we had the actual physical phone that was taken from Mr. Tellis, correct?
Even having the actual physical phone might not lead to that information.
Okay. But then to assume that if we have it on an Apple Watch and not have it on this extraction, we can't say that it was deleted, correct? Because this is just the extraction.
This is just an extraction of this specific device.
Thank you. No further questions.
Okay, anything else for this witness? Okay, it looks like we have a question. Okay, and that question from a juror has been marked as Court's Exhibit 22. If someone airdrops pictures, would you know if the pictures are on the phone due to an airdrop? And if so, can you tell who did the drop of the pictures?
I don't have a lot of personal experience investigating that specific question, but in this instance, you wouldn't. Just taking this phone as a Google phone wouldn't be AirDrop compatible. That's an Apple function.
Thank you. Any follow-up from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Okay. Thank you very much for your testimony here today. You may step down. And you are now excused from your subpoena. Thank you very much for coming back today. Does the state have any further witnesses that they intend to call in rebuttal?
No, Your Honor.
Okay. And Mr. Draskovich?
No, Your Honor. Thank you.
Okay. All right. At this time, ladies and gentlemen, you have heard all of the evidence that will be introduced in this trial. We are going to conclude for the day. When you come back on Monday morning, you will be instructed on the law, and then both sides will be permitted to speak to you in their closing argument, and then you'll be excused to deliberate upon your verdict. I just want to make sure, is 9:30 okay with the parties, Monday? All right, so we are going to start Monday morning at 9:30. During this recess, you're admonished not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or the means of communication, or social media. Read, watch, or listen to any news or media accounts or commentary about the case. Do research, consult dictionaries, internet, or reference materials. Do any investigation. Test a theory, recreate any aspect of the case, or in any other way investigate or learn about the case on your own, or form or express any opinion regarding the case until it's finally submitted to you. Thank you very much. Have a good weekend. We'll see you Monday morning.
Thank you. All right. Thank you, jury.
Approach, and I give you your copies of the jury instructions, and then we can at least formally settle these instructions. Oh, I'm sorry.
No worries.
I'll give.
Okay. Okay, is the state familiar with court's proposed instructions 1 through 32?
Yes, Your Honor.
Any objection?
No, Your Honor.
Any further instructions the state would like to propose?
No, thank you.
Is the defense familiar with court's proposed instructions 1 through 32?
Yes, Your Honor. We've reviewed them.
Any objections?
No objections.
Any further instructions you'd like to propose?
Not that has been already incorporated within our jury instructions.
All right, so these instructions will be logged with the clerk, and the jury will get a copy of them on Monday morning. I know if we need to talk about the other instructions, so if you just give me a few minutes.
Absolutely.
And we can go back in chambers. Thank you.
We approach you, Honor?
Sure.
Thank you.
All rise for entering jury. Jurors.
Okay, good morning, ladies and gentlemen. Does the state stipulate to the presence of the panel?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
Okay, at this time, ladies and gentlemen, I am going to instruct you on the law. Officer Hawks is handing out the jury instructions. Each of you will have a copy of the instructions. You'll be able to take them with you when you go back to deliberate upon your verdict. It is now my duty as judge to instruct you in the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of the court. Instruction number 2, if in these instructions any rule, direction, idea is repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions are given has no significance as to their relative importance. Number 3, an indictment is but a formal method of accusing a person of a crime and is not of itself any evidence of his guilt. In this case, it is charged an indictment that on or about the 2nd day of September 2022 within the County of Clark, State of Nevada, contrary to the form, force, and effect of statutes in such case is made and provided, and against the peace and dignity of the State of Nevada, the defendant committed the crime of murder with use of a deadly weapon, victim 60 years of age or older, as follows. Did willfully, unlawfully, with malice aforethought, kill Jeffrey Gehrman, who was 60 years of age or older, with use of a deadly weapon, to wit, a knife, by stabbing the said Jeffrey Gehrman multiple times about the body, the said killing having been 1, willful, deliberate, and premeditated, and or 2, perpetrated by lying in wait for the said Jeffrey Gehrman, and or 3, perpetrated by abuse of an older person. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case and determine whether or not the defendant is guilty of the offense charged. Number 4, murder is the unlawful killing of a human being with malice aforethought, either express or implied. The unlawful killing may be effected by any of the various means by which death may be occasioned. Number 5, malice aforethought means the intentional doing of a wrongful act without legal cause or excuse, or what the law considers adequate provocation. The condition of mind described as malice aforethought may arise from anger, hatred, revenge, or from particular ill will, spite, or grudge toward the person killed. It may also arise from an unjustifiable or unlawful motive or purpose to injure another, proceeding from a heart fatally bent on mischief, or with reckless disregard of consequences and social duty. Malice aforethought does not imply deliberation or the lapse of any considerable time between the malicious intention to injure another and the actual execution of the intent, but denotes an unlawful purpose and design as opposed to accident and mischance. Number 6, express malice is that deliberate intention unlawfully to take away the life of a human being which is manifested by external circumstances capable of proof. Malice may be implied when no considerable provocation appears, or when all of the circumstances of the killing show an abandoned and malignant heart. Number 7, the indictment alleges alternative theories of murder of the first degree, as allowed by law. In addition to willful, deliberate, premeditated murder, the indictment alleges the defendant committed the murder by means of lying in wait and or by abuse of an older person. Number 8, one theory of murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. All 3 elements, willfulness, deliberation, and premeditation, must be proven beyond a reasonable doubt before an accused can be convicted of first-degree murder under the theory of liability. Number 9, willfulness is the intention to kill. There need be no appreciable space of time between formation of the intent to kill and the act of killing. Number 10, deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of the actions. A deliberate determination may be arrived at in a short period of time, but in all cases, the determination must not be formed in passion, or if formed in passion, it must be carried out after there has been time for the passion to subside and deliberation to occur. A mere unconsidered and rash impulse is not deliberate, even though it includes the intent to kill. Number 11, premeditation is a design, a determination to kill, distinctly formed in the mind by the time of the killing. Premeditation need not be for a day, an hour, or even a minute. It may be as instantaneous as successive thoughts of the mind. For if the jury believes from the evidence that the act constituting the killing has been preceded by and has been the result of premeditation, no matter how rapidly the act follows the premeditation, it is premeditated. Number 12, the law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. The true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not deliberation and premeditation, as will fix an unlawful killing as murder of the first degree. Number 13, another theory of murder of the first degree is murder perpetrated by means of lying in wait. The elements necessary to constitute lying in wait are watching, waiting, and concealment from the person killed with the intention of inflicting serious bodily injury upon such person or of killing such person. Nothing requires that the lying in wait exist for or consume any particular period of time before the act which causes the death. It is only necessary that the act causing death be preceded by and the outgrowth of lying in wait. Where a killing is accomplished after lying in wait, the state is not required to prove premeditation or deliberation. The killing constitutes murder of the first degree so long as it was committed with malice, either express or implied. Number 14, another theory of murder of the first degree is a kind of murder which carries with it conclusive evidence of malice aforethought. One of these classes of murder is murder committed in the perpetration or attempted perpetration of abuse of an older person. Therefore, a killing which is committed in the perpetration or attempted perpetration of abuse of an older person is deemed to be murder of the first degree, whether the killing was intentional or unintentional or accidental. This is called the felony murder rule. The intent to perpetrate or attempt to perpetrate abuse of an older person must be proven beyond a reasonable doubt. Number 15, any person who abuses an older person is guilty of abuse of an older person. Abuse means willfully causing unjustifiably pain or injury or mental suffering to an older person. An older person is defined in Nevada as 60 years of age or older. Number 16, although your verdict must be unanimous as to the charge, you do not have to agree on the theory of guilt or liability. Therefore, even if you cannot agree on whether the facts establish the defendant is guilty of willful, deliberate, and premeditated murder, murder by means of lying in wait, or felony murder by means of abuse of an older person, so long as all of you agree that the evidence establishes the defendant's guilt of murder in the first degree, your verdict shall be murder of the first degree. Number 17, all murder which is not murder of the first degree is murder of the second degree. Murder of the second degree is murder with malice aforethought, but without the admixture of premeditation and deliberation, nor by means of lying in wait or by means of elder abuse. Number 18, you are instructed that if you find the state has established that the defendant has committed first-degree murder, you shall select first-degree murder as your verdict. The crime of first-degree murder includes the crime of second-degree murder. You may find the defendant guilty of second-degree murder if, 1, you have not found beyond a reasonable doubt that the defendant is guilty of murder of the first degree, and 2, all 12 of you are convinced beyond a reasonable doubt the defendant is guilty of the crime of second-degree murder. If you are convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but you have a reasonable doubt whether such murder was of the first or of the second degree, you must give the defendant the benefit of that doubt and return a verdict of murder of the second degree. Number 19, you are instructed that if you find the defendant guilty of first or second degree murder, you must also determine whether or not a deadly weapon was used in the commission of the crime. If you find beyond a reasonable doubt that a deadly weapon was used in the commission of such an offense, then you shall return the appropriate guilty verdict reflecting with use of a deadly weapon. If, however, you find that a deadly weapon was not used in the commission of such an offense, but you find that it was committed, then you shall return the appropriate guilty verdict reflecting that a deadly weapon was not used. Number 20, deadly weapon means any instrument which, if used in the ordinary manner contemplated by its design and construction, will or is likely to cause substantial bodily harm or death, or any weapon, device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing substantial bodily harm or death. 21, the state is not required to have recovered the deadly weapon used in an alleged crime or to produce the deadly weapon in court at trial to establish that a deadly weapon was used in the commission of the crime. Number 22, in arriving at your verdict in this case as to whether the defendant is guilty or not guilty, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict. If your verdict is murder of the first degree, you will, at a later hearing, determine the issue of penalty or punishment. Number 23, to constitute the crime charged, there must exist a union or joint operation of an act forbidden by law and an intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charged, and the state is not required to prove a motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. Number 24, the defendant is presumed innocent until the contrary is proved. This presumption places upon the state of Nevada the burden of proving beyond a reasonable doubt every element of the crime charged and that the defendant is the person who committed the offense. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life if the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they can say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, he is entitled to a verdict of not guilty. Number 25, the evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are two types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime which has been charged, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all of the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorneys stipulate to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proved. You must not speculate to be true any insinuations suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Number 26, in this trial, you heard evidence of other acts regarding the defendant, Mr. Tellis, in the articles written by Jeff Gehrman. You are not to conclude from this evidence the defendant is a person of bad character or is predisposed to commit crimes. Number 27, the credibility or believability of a witness should be determined by their manner upon the stand, their relationship to the parties, their fears, motives, interests, or feelings, their opportunity to have observed the matter to which they testified, the reasonableness of their statements, and the strength or weakness of their recollections. If you believe a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of their testimony which is not proved by other evidence. Number 28, witnesses who have special knowledge, skill, experience, training, or education in a particular subject have testified to certain opinions. This type of witness is referred to as an expert witness. In determining what weight to give an opinion expressed by an expert witness, you should consider the qualifications and believability of the witness, the facts or materials upon which the opinion is based, and the reasons for each opinion. Opinion is only as good as the facts and reasons on which it is based. If you find that any fact has not been proven or has been disproved, you may consider that in determining the value of the opinion. Likewise, you must consider the strength or weaknesses of the reasons on which it is based. You are not bound by any opinion. Give each opinion the weight you find it deserves. You may disregard any opinion if you find it to be unreasonable. Number 29, although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in the light of common experience, keeping in mind such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. Number 30, during your deliberations, you're not to communicate with anyone in any manner regarding the facts and circumstances of this case or its merits, either by phone, email, text, messaging, internet, or other means. You are admonished not to read, watch, or listen to any news or media accounts or commentary about the case. You're not permitted to do any independent research, such as consulting dictionaries, using the internet, or any other reference materials. You are further admonished not to conduct any investigation, test a theory of the case, recreate any aspects of the case, or in any other manner investigate or learn about the case on your own. Number 31, when you retire to consider your verdict, you must first select one of your members to act as foreperson who will preside over your deliberation and will be your spokesperson in court. During your deliberation, you will have all the exhibits admitted into evidence, these written instructions, and forms of verdict prepared for your convenience. Your verdict must be unanimous. As soon as you agree upon a verdict, the foreperson shall sign and date the verdict form and return with it to this room. Number 32. Now you will listen to the arguments of counsel, who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind it is your duty to be governed in your deliberation by the evidence as you understand it and remember it to be, and by the laws given to you in these instructions, with the sole fixed and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. The state may open and close the arguments.
Thank you, Your Honor. Morning. By June of 2022, Jeff German had caused a lot of problems for the public administrator, Robert Tellis. He had written articles accusing Mr. Tellis of an inappropriate relationship. He had written that he was bullying in the office and had created a hostile environment in the public administrator's office. He had written an article saying that the management of Mr. Tellis was so bad that the county had to bring in a private consultant in order to assist with the management of an 8-person office. After Mr. German wrote those articles, Mr. Tellis lost his primary race and would not be the public administrator after that. And not just that he lost the race, he lost the race to a rival within the public administrator's office itself. And from the text messages of Mr. Tellis, we learned that this was deeply, deeply troubling for him. He wrote to Mr. German, "I don't know what to say. I told you how much this all impacted me. You heard from employees who are being harassed by these people, provided you," I think this is a typo, "proof that I was doing my best to actually smooth things over. I had to make hard decisions. Still, you wrote an article that makes it sound like I'm the guilty one. That wasn't fair or balanced." He told Mr. German, "I'm distraught right now. Clearly there are typos in my message." He told Mr. German that he was adding to the pressure of his life. "I've done so much for that office. I've told you that I've been followed and that I caught Rita following me. You decided to take it on her word that she wasn't. However, clearly she was. It seems to me that you valued sensationalism or the value of a potential takedown than actually telling the truth. Thank you for helping him drop more pressure on my life." Now, Mr. German's response was a response that you'd get probably from many reporters. He says, "Sorry you feel that way. My editors and I feel the story is fair and balanced." Mr. Tellis's response, "I don't know that you could truly feel that. You have concrete proof I provided you of what is really going on. You acknowledge much of it. Still, you mention none of it. If telling yourself that you were fair helps you sleep at night while you're trying to destroy good people, that's your prerogative." And Mr. Tellis does attempt to fight back from these articles. On his campaign website, he posts this letter discrediting the paper and discrediting the allegations in those articles written by Mr. Gehrman. He goes on Twitter and he accuses Mr. Gehrman of being a bully. He says Mr. Gehrman had threatened him. He told other people on social media in this first screenshot that because of those articles, I had to increase my medication to cope with it all. He tells someone who reposted the article or sent it that he was deeply disappointed that they had done that. And he's generally following the fallout of those articles on social media. But the reality is he lost that primary election after those articles were written, and he attributed it to the articles written by Jeff Gehrman. He told his best employee, Nicole Lofton, unfortunately, too many people bought the lies. He told his best employee, Nicole Lofton, I'm so sorry, I'm devastated that everything we worked for is going to be done. I hate them and what they did. And after all that happened and losing the primary, his concern was that another article might be coming. He explains, I'm going to pull the trigger on the supervisory changes. I'm going to go with the original plan. I think if I do any more than that, they will say I'm interfering with operations. And then he added, she is probably trying to get fodder to pass to the reporter. And he sent another text after that there's more garbage being gathered for a news article. And Mr. Tellis testified to you that after the primary took place, he actually half drafted, he didn't file it, a lawsuit where he was going to sue his rival, Rita Reed, and he was going to insinuate in that lawsuit, coincidentally, that there was a conspiracy that caused his problems in the election. If you look at point 21, he wrote, upon information and belief, several employees conspired to make false allegations of mistreatment by Mr. Tellis. These employees contacted the Las Vegas Review-Journal to share false and defamatory statements in support of news articles against Mr. Tellis. So he was clearly incredibly upset that those articles were written and that it resulted in him losing that primary. In July, Jeff Gehrman, though, isn't done with his stories and his examination of what is going on with Mr. Tellis and the public administrator's office. In July, he sends that request for the public records of the county, where he's asking for communication between Mr. Tellis and Roberta, and then ultimately it expands to other individuals in the county. But he wants all team messages between Mr. Tellis and Roberta. He wants cell phone messages. He wants essentially all of their communications as of July, and that's after those 4 articles were written. Mr. Tellis, of course, is informed by this, informed of this request by the county, and this occurs on August the 8th, and they explain, hey, look, this reporter's seeking all of this information, so the message underlying all of this is another article is forthcoming. Mr. Tellis messages back that he wants to review those communications prior to them being released to the reporter. But as of August 8th, he's on notice of another article coming. And if you look at this email, he responds about 20 minutes after that first email was sent to him. Now, looking at the August calendar, you can see that on August the 8th, that's when he receives the notification of the public records request. And by August the 12th, there are images from Google Maps of Jeff Gehrman's neighborhood, Bronze Circle. We don't know the date they were created, but we know they were modified by August the 13th, meaning they had to be created sometime before that. Now, this doesn't mean that Mr. Tellis physically went to Bronze Circle on the days leading up to the modification date of the 13th. It simply means that he went and accessed Google Maps, and Bronze Circle is the area that was searched and accessed by his phone. And those images are, of course, where Jeff Garman lives. Now, the next date to keep in mind in our series of events in August of 22 is August the 15th. In August the 15th, that is when there's images of all of those cars that are kind of driving along the access road to Jeff Garman's neighborhood. Now, once again, we have a modification date. That doesn't mean that the images were all taken on the 15th, but they had to exist before the 15th to be modified on that date. And if you recall, Detective Gaddis figured out where this was, and it's right off of Mr. Garman's neighborhood. His house is right here on Bronze Circle, and she figured out by looking at the photographs where it was located in Las Vegas. And she figured out it was located right at this Popeyes parking lot, and that slanted wall ends up being in almost all of the images. And there are a lot of them, of several cars driving by the access road to Mr. Garman's house. So we have the notification on the 8th, we have accessing Google Maps on the 12th, we have those screenshots of all of those vehicles in conjunction with Mr. Garman's neighborhood by the 15th, and then by the 23rd, there have been searches of Mr. Garman's personal information on Mr. Tellis's computer. This is Mr. Tellis's work computer at his desk. If you look at the screen on the right, you can see like there's a bottle of hand sanitizer, there's an arrow pointing to it. Here's a closer view. And the screenshots from his phone, you can see that the same cap to that bottle is in the screenshot as well. So these were clearly taken on his work computer while he was at work. And you can see that he's looking up personal information of Mr. Garman, the kind of car he drives. He ultimately is able to get the address of 7216 off his work computer. And once again, those photos were in existence by August the 23rd of 2022. So all of those events, the notification, the accessing of Bronze Circle on Google Maps, the screenshots of the car, and then using the work computer to access personal information of Jeff Garman all occurs in August of 2022. Moving to September, that's when Mr. Tellis, on September the 1st, receives notification that the county is getting ready to release all of those documents that were subject to the public records request. He's notified, and Ms. Kennan is notified on September the 1st of 2022, and the murder's the very next day. It's about 15 hours later. Now, we know that on the morning of the 2nd, Mr. Tellis left his house and proceeded into the area of Mr. Garman's neighborhood, and that he kind of meanders around there, but ultimately ends up on those cross streets and then proceeds on foot to Mr. Garman's residence. Mr. Tellis's residence is at the top of the screen there on Spanish Steps. He goes down that Silk Tassel Road and then goes on Red Hills Road. And he leaves at 9:12 in the morning. Now, eventually, he's in the area of Rock Springs Drive, which is near Mr. Garman's neighborhood. The time on that video is incorrect. It says 9:42 a.m. But you heard from Detective Mogg that the corrected time for that particular camera is 10:26. So he's in the area of Mr. Garman's neighborhood at about 10:26 a.m. in the morning. What's the next thing that happens? Well, you know that this is Mrs. Tellis's Apple Watch, and she sends that message to Mr. Tellis at 10:35 a.m. You can kind of see it says Friday 10:35 a.m. And the message is, where are you? Well, he's sitting in Mr. Garman's neighborhood, so he's not answering this text message. That text message goes unanswered. Mr. Tellis at 10:40 a.m. is now on Wintergreen Drive, which is the cross street to Bronze Circle. He's on Wintergreen Drive at about 11 a.m., and the murder itself takes place at about 11:18 a.m. Then Mr. Tellis is back at his own neighborhood by 11:51 a.m. And this is video from that Piggott Elementary School, which Detective Mogg indicated that that timestamp is correct. And what does he do? He gets back at 11:51 a.m., and then he's able to get his BMW and proceed to Planet Fitness. So there's his BMW leaving. It's 12:03, and then you know from Detective Gaddis's testimony that it's about a 4 to 6 minute drive. He's able to be at Planet Fitness by 12:09. So by 9/3, which is now the day after the murder, it has been reported that Jeff Garriman has been murdered. And then Roberta, who's working, has heard about the murder, and she's starting to get concerned. She tells Mr. Tellis, I'm working tomorrow now. I don't want to be in the office alone. I'd rather be with the crazy women than alone right now. She's concerned about Mr. Garriman getting murdered, and she's scared about being in the office alone. By September 5th and 6th, the Las Vegas Metropolitan Police Department has released images of the assailant and also of the Yukon itself. And Roberta becomes even more concerned. She messages Mr. Tellis, Rob, WTF, please do not be driving your Yukon around for a while. This is on September the 6th. He answers, whoa, that's crazy. She says, please tell me your Yukon is not that color. He answers, it is similar, if not the same. She says, I'm freaking out, Rob. He answers, my car has all matching wheel patterns. I think they are saying that there's a difference between the front and the back of the assailant's vehicle. But Roberta looks at it and says, fuck, your car is identical. And it actually turns out that Roberta is the one that is correct. His car is identical. From that lighter spot on the passenger side, just below the windshield wiper, there's sort of like a lighter rectangular shaped portion of the car. You can see that in the video. From the differentiating tint between the front and the back of the vehicle, that part is identical. And from the wheels themselves, they weren't different. They were the same. The wheel rims on the front and the back are identical. It is his Yukon. He is the one who committed the murder. So let's talk about the charge of murder. Murder is the unlawful killing of a human being with malice aforethought, either express or implied. And all that means is an act of ill will. When you go back to deliberate, you'll be asked two overarching general questions about the crime. And those are, was a deadly weapon used in the commission of the crime? And was the victim of the crime 60 years of age or older? So as you heard from Judge Levitt, a deadly weapon is simply an object capable of causing substantial bodily harm or death. We obviously have that in this case. The knife wounds inflicted on Mr. Garriman were definitely not caused by human hands, and they were capable of causing substantial bodily harm or death, because that's ultimately what happened. You may be asking, well, where is it? Like that knife didn't come to court. But the instructions tell you that the state is not required to have recovered a deadly weapon used in an alleged crime or to produce it at trial. You just have to be able to gather from the evidence that a deadly weapon was used. Obviously, the injuries of Mr. Garriman indicate that this was not caused by human hands. A deadly weapon was used to accomplish his murder. So that overarching question about the crime is probably an easy one to answer. Probably the easiest one after that is, was Mr. Garriman over 60 years old at the time the crime occurred? And he was 69 years old at the time it occurred. So let's talk about first-degree murder. As Judge Levitt explained to you, there are three theories, three pathways that you can reach a verdict of first-degree murder. The first one is a willful, deliberate, and premeditated murder. The second one is murder perpetrated by means of lying in wait. And the third one is murder perpetrated during the course of elder abuse. Now, the first form of first-degree murder is probably the one you're the most familiar with, and that is a murder that is willful, deliberate, and premeditated. And you'd have to find all of those elements in order to find Mr. Tellis guilty under that theory of first-degree murder. So let's talk about what each of these mean. Willfulness is very simple. It's simply an intent to kill. Do your actions demonstrate an intent to kill? So this part of the video takes about 2 minutes. The entire time of that 2 minutes, Mr. Tellis is attacking Mr. Garriman with a weapon. So that demonstrates an intent to kill. He's stabbing him repeatedly. Mr. Garriman is clearly trying to fight back, but Mr. Tellis doesn't stop. It keeps going and going and going. And it's kind of a long time to be inflicting injuries on another individual. He finally walks out on the side. But the duration of that time, the entire time, Mr. Garriman is being attacked. So let's talk about deliberation, which is the second element. Deliberation is determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action. Well, what do we know about Mr. Tellis's actions prior to the murder? Well, we know back in August, when he got notification that another story was likely coming, he kind of goes into research mode on Mr. Garriman, where he's located, what kind of car he might be driving, searches on his computer. All of that demonstrates deliberation. Even if you didn't have all of these actions back in August, the length of time of the actual attack itself is sort of a shorter version demonstrating a course of action to kill, right? In the course of 2 minutes, you are stabbing someone multiple times, you could change your mind, but he doesn't do that. He keeps going and going and going, not even withstanding all this pre-planning. Now, premeditation is the last element of that first theory of first-degree murder, and that is simply a decision to kill before you do it. Before you came in and sat as jurors, you may have thought that premeditation is always a case of pre-planning and months in advance and that sort of thing. And that is definitely a case of first-degree murder and kind of exactly what we have in this case. But you're told by the instruction that premeditation need not be for a day, an hour, or even a minute. It can be as instantaneous as successive thoughts of the mind. So what that instruction tells you is, in the law of Nevada, for premeditation, if I make a decision to kill you and I do it a month from now, that's premeditation. If I make a decision to kill and I do it a week from now, that's premeditation. If I do it an hour later, it's premeditation. If I do it a minute later, it's premeditation. If I do it a second later, it's still premeditation. And you have a video of the attack on Mr. Gehrman, and clearly there's a decision made to kill him. But beyond that, you also know that Mr. Tellis took the step of leaving his phone at home prior to the murder. That's indication of premeditation and planning. You know that he bothered to disguise himself by wearing the hat and the orange outfit. That shows premeditation, a decision to kill. And you also know, most of all, that he brought a weapon over to Mr. Gehrman's house, and that shows premeditation as well. So that theory of first-degree murder has been established in this case. Let's talk about the second theory of first-degree murder, which is murder perpetrated by means of lying in wait. And the instructions explain what that is. Another theory of first-degree murder is murder perpetrated by means of lying in wait. And what that is kind of taking on a place of concealment in order to inflict injury or death upon another person. It's sort of the second paragraph. It says, watching, waiting, and concealment from the person killed with the intention of inflicting serious bodily harm upon, or serious bodily injury upon such person, or of killing such a person. And in this case, you actually see the actions of Mr. Tellis literally lying in wait. He goes into Mr. Gehrman's yard and recedes to the back in order to be in a place of concealment in order to attack him later on. And that is literally lying in wait. So that theory of first-degree murder is established as well. The third theory of first-degree murder is murder occurring during the perpetration of abuse of an older person. And this is kind of like child abuse, where if you abuse a child and a child happens to die in the course of abuse, it's automatically first-degree murder. The same is true for individuals who are over 60. If you abuse an older person and they die during the course of that abuse, that is an automatic case of first-degree murder. And it's sort of a policy judgment to protect vulnerable members of our society. The instructions tell you another theory of first-degree murder is a kind of murder which carries with it conclusive evidence of malice aforethought. One of these classes of murder is murder committed in the perpetration or attempted perpetration of abuse of an older person. Therefore, a killing which is committed in the perpetration or attempted perpetration of an older person is deemed to be murder of the first degree, whether the killing was intentional, unintentional, or accidental. We have that in this case. Mr. Gehrman was over 60 years old, so by abusing him and causing his death, it is automatically another theory of first-degree murder. So this is a picture of the verdict form that you'll have back in your deliberation room, and you can kind of see on the top in all caps it says murder with use of a deadly weapon, victim 60 years of age or older. That was those very first two questions I discussed with you at the beginning of the closing that you would answer as jurors. And then as a jury, you should ask about the individual theories of first-degree murder and vote on them. So you have to vote if all 12 of you think that this was a willful, deliberate, and premeditated murder. Do all 12 of you find that it was perpetrated by means of lying in wait? Do all 12 of you agree that it was perpetrated in the course of abuse of an older person? If you find all of those, then you mark those boxes. if you are in disagreement, say only 3 of you think it was willful, deliberate, and premeditated, or some combination, you have to take a vote to decide if all of you believe that it's first-degree murder under some theory. And if it is, you mark that last box and say, we don't find unanimously under any of those 3 theories, but all of us agree, 12 of us agree that it's some form of first-degree murder. The law tells you, although your verdict must be unanimous as to charge, you do not have to agree on a theory of guilt or liability. So if all 12 of you agree one form of first-degree murder, then you mark that last box. But it's the state's position that all 3 of those theories, willful, deliberate, premeditated, lying in wait, and elder abuse, clearly apply in this case. And really, Mr. Tellis isn't disagreeing that this is a case of first-degree murder. He's just saying that it was a Compass Realty assassin who did it. Now here we see Mr. Tellis leaving his house at about 9:12 a.m. And it's the state's theory, of course, that at that point he's left his house and his cell phone is sitting back at his house on Spanish Steps. The state's theory is that Mr. Tellis leaves his residence, leaves the phone at the residence, and is proceeding to Mr. Gehrman's residence. And as we've discussed, the Yukon is seen at Rock Springs at about 10:26 a.m. Here's 2 different images of it. Meanwhile, Mr. Tellis's cell phone, which is sitting back at Spanish Steps, is getting some incoming messages. There's an incoming and unanswered message at about 9:44 a.m. about a work case. There's an incoming and unanswered message at about 10:16 about another case at his work. There's an incoming unanswered message from his wife saying, "Where are you?" at 10:36 a.m. Now you'd think, given that some of the allegations in the articles, this might be one he'd answer pretty quickly. There's an unanswered incoming call from his wife at 10:43 a.m. that doesn't get answered by him. And there's another incoming call that occurs at 11:16 a.m. Meanwhile, he is at Mr. Gehrman's house. So ask yourself this. If this was really a Compass Realty assassin who was committing the murder at Bronze Circle, how would that individual know that Mr. Tellis, with his phone at his house, wouldn't have answered a call, or wouldn't have gotten in another text string, or wouldn't have made a call himself? How could anybody but Mr. Tellis be the killer? No one would have that level of assurance, because if any of those calls had been answered from his house, it would be clear that he wasn't the one involved. Now we know from the video evidence from Bronze Circle that after the murder occurs, Mr. Tellis actually returns to Mr. Gehrman's house, and he goes to the side area of the yard where Mr. Gehrman is located. And then he returns back to the Yukon. And eventually does that U-turn and drives away. But if you're wondering why there isn't blood in the Yukon, he had to walk all the way out of that crime scene, and anything that had been deposited on his shoes would have come off in the rocks. Besides that, the crime scene itself is not drenched in blood on the ground. These are Mr. Gehrman's shoes. There is some blood on them, but they're not exactly drenched, and he's the victim. So after Mr. Tellis leaves Bronze Circle for the second time, he goes east, he goes on Wintergreen, he goes on Washington, he goes on Rampart, he goes on Apple, and he goes back to his neighborhood at 11:51, and then he leaves again to go to Planet Fitness at about 12:03. You also know that Mr. Tellis is the killer because of the DNA evidence in this case. Remember how this comes into play. They collect the samples from the scene, and the Metro DNA analyst has this result of foreign DNA being present on September the 5th. They haven't even collected a DNA sample from Mr. Tellis until the 7th. So it's not like Metro or Compass Realty has a sample of Mr. Tellis's DNA to come insert in this crime scene. It's Mr. Tellis's DNA in this scene. It's literally on the body of Mr. Gehrman. The items from the search warrant also tell you that Mr. Tellis is the person responsible for this crime. Those shoes that were found in the house, they weren't planted, they were hidden. They were cut up. Anyone who planted the shoes would have no reason to cut them up. The cutting up is to benefit Mr. Tellis so he can get rid of them. If you were just planting them, you could leave them alone. And they're clearly his shoes because 1, they're in his house. 2, his DNA is present on them. And if you don't believe that, there's pictures in his phone of those shoes on a day when he apparently went rock climbing. You have the bag that was located and ultimately the hat as well. And you heard a lot of testimony about how all of this evidence was collected from the scene. There's the detective who physically finds it, working with other detectives who are also doing the search. There's the detective that's assigned to be the scribe, to write down where everything is located. There's a crime scene analyst assigned to photograph it in place. There's DNA analysts who actually analyze the physical evidence after the fact. And all of this occurred, this whole search occurred while his wife is sitting in the house and aware of what they're doing. None of this evidence was planted. There's the bag, there's the hat, that was the location of the hat in his house. Finally, you know from the searches the Bronze Circle where he accessed the Google Maps, Mr. Gehrman's house, that he is the one responsible. He's not friends with Mr. Gehrman. He doesn't have business to do with Mr. Gehrman. There is no reason for images of Bronze Circle to be in his phone prior to the murder occurring. You also know that he is the one responsible from the sort of amateur surveillance that occurred in August prior to the murder itself. There's no reason for any of this to be in his phone, but that he's attempting to gather information on Mr. Gehrman. And finally, you know he actually used his work computer to gather information on Mr. Gehrman as well. At the end of his testimony, I think yesterday, Mr. Tellis explained that he's really a victim in this. He's been victimized by the whole process. And he told you that he was wronged by his coworkers who didn't appreciate his changes that he made in the office and didn't appreciate his management style. He was wronged by the county who didn't understand that he was being a good leader. He was wronged by Zach Schilling, and by Kristen Riffle. He was wronged by them as well. He was certainly wronged, according to him, by Compass Realty. He was wronged by Steve Wolfson. He was wronged by the patrol officers who preserved that scene at Mr. Gehrman's house. He was wronged by Metro Police, in particular Detective Gaddis and Detective Jappy. He was wronged by some mysterious, illusory phone hacker. He was wronged by DNA analysts at Metro who found his DNA on the fingernails of Mr. Gehrman, and then of course he was obviously wronged by Mr. Gehrman too in the articles he wrote. Or maybe it's not that he was wronged. Maybe he's the one in the wrong.
Thank you very much. At this time, we're going to take a 10-minute recess. During this recess, you're admonished not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media, or read, watch, or listen to any news or media accounts or commentary, do research, consult dictionaries, the internet, or reference materials, do any investigation, test a theory, recreate any aspect of the case.
Thank you, everyone. Please be seated. Please come to order. Court is now back in session.
Does the state stipulate to the presence of the panel?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
Mr. Faskich, you may begin your closing argument.
Thank you. Am I on? Proof beyond a reasonable doubt. It's the highest standard in this country. It's not presumption, preponderance of the evidence. It's not clear and convincing. It's proof beyond a reasonable doubt. This concept was borrowed from the Old English common law. Our founding fathers thought that it'd be better to let 10 guilty men go free than to wrongfully convict an innocent person. Additionally, I would submit to you that it reflects the reality that very few people have the resources, the means, the wherewithal to prove their innocence. You know, you heard testimony by narrative by the defendant, Mr. Tellis. Generally, you don't discuss a person being in custody, but he testified truthfully from the stand concerning his incarceration. He had testified that he'd been in custody for 2 years and that he wanted to tell you his story. Jury instruction numbers 27 discusses a witness's manner upon the stand. You and you alone are to judge every witness's credibility. In jury instruction number 3, it states that you are to apply the law to the facts. As we had stated at the beginning of this trial, you are the sole judges of the facts in this case. We had asked you at the beginning if you would keep an open mind, and we're certain that you have. This case is not about who called the most witnesses. The state did. This case is not about who had the most exhibits presented to you. The state did. We had asked you that at the close of evidence and at the end of this trial, if we were to sit at counsel table with Mr. Tellis and not ask a single question, not discuss a single document, not to submit a single document, if you had a doubt, and if it were a reasonable one, he'd be entitled to a verdict of not guilty. Let's talk for a minute what the state hasn't proven. And again, there is no burden whatsoever on that man. Jeff Gehrman DNA wasn't anywhere but at the scene of the crime. And this is significant because we heard a very able explanation of the state's evidence from their point of view. There was no blood or DNA evidence concerning Mr. Gehrman in Mr. Tellis' home, in or on his vehicles, in or on his clothing. None of that would implicate Mr. Tellis. There had been discussion on the state's closing wherein there was blood everywhere in this, in the bronze circle address. Obviously, it was a stabbing. You can see through the exhibits that you will have with you in the jury room. There was blood everywhere, on the bushes, on the bird dish. Nowhere in Mr. Tellis's vehicle do we find blood. You recall the testimony, blood presumptive negative on both doors on the driver's side, the seat belt, the brake pedal, the gas pedal, the mat, nothing. There was no blood on his person, clothing, anything else. You didn't hear from any witnesses concerning any personal knowledge to contradict Mr. Tellis's version of the events for September 2nd. There was not a positive identification of the subject vehicle or Mr. Tellis at the scene. There's no evidence whatsoever of any gloves being recovered. And you've seen, and it's fairly clear from the video evidence that you've been presented, that assailant was wearing gloves. There was no recovery of a murder weapon. That vest with the reflective strips, you didn't see that. And the pants, I mean, we had pants that were recovered. You saw the blue pants. Obviously, that didn't bear any evidence to implicate Mr. Tellis. And I would submit to you that the facts and common sense would dictate that had he been the murderer, there'd be evidence of it on these articles, on that getup that that person was wearing on September 2nd. This is a point that I would urge you to consider, because I would submit to you that's crucial in determining whether the state, and again, it's the state alone that bears the burden, has proven their case against Mr. Tellis. There's no surveillance or eyewitness testimony showing that Tellis left his house that day headed to Mr. Gehrman's home. We did hear evidence, and it was uncontroverted, and that came through Detective Gaddis, that on the day of the stop, September 2nd, it's Metro policy to have body cam. The officers that stopped him in relation to the warrant that was obtained with Mr. Jappy's, Detective Jappy's participation, it was issued at 2 a.m. on the 7th. The officers that stopped Mr. Tellis, the officers that detained Mr. Tellis, didn't have the body cam on, and that was requested multiple times. Ultimately, there was an order from Her Honor on July 18th of 2023, and after that order. And you recall going through the cam, the reports, the CAD reports, there was intervention, but again, that key piece of evidence was overwritten, it was destroyed. Again, is that indication of some wide-ranging conspiracy? And I'm not going to stand before you today and necessarily argue that there was. But what that shows is that Metro makes mistakes. Metro officers, Metro detectives are human. I mean, you think of the old proverbial idea of police officers, their brass buttons, blue uniforms. They're human beings underneath their titles, underneath their uniforms, and they're just like all of us. They make mistakes. That shows you that mistakes are made on behalf of Metro. And the Las Vegas Metropolitan Police Department is not infallible. Let's talk about Robert Tellis's blood, or the lack thereof, at the scene of the murder. You had seen some pretty good videos capturing that person leaving Jeff Gehrman's house after the stabbing. I would submit to you that it's the state's argument that Mr. Tellis cut himself through that incident. You heard his testimony. You are the sole judges of the facts concerning that. What we do have, in addition to the state's video, is we have this assailant walking away from the 7217 Bronze Circle address. That finger was cut. That finger had been damaged by a knife or otherwise severely injured. Wouldn't there be blood? Wouldn't common sense dictate that there'd be blood in the bushes surrounding Jeff Gehrman's body, in the rocks which were recovered, in the sidewalk outside the house? Nothing. And again, it's the state's burden to present you every bit of evidence in their prosecution, and you should take into consideration the evidence that they've presented to you. But by the same token, you should take into consideration determining whether or not they have proved their case beyond a reasonable doubt and they have the sole burden for the production of evidence. Ask yourselves what evidence is missing. Let's talk about Robert Tellis's body in relation to a struggle that the state would have you believe occurred between these two gentlemen. Recall the evidence that we had brought in during their presentation of evidence, and I believe a number of these pictures came through Detective Gaddis. And there's a lot. It's defense exhibits B through V. This is just kind of a capture of these photos, and there's a lot of them to evidence that there were no injuries to his body. Neck, front, and there's more, and we could stand here and click through each and every one, but we're not going to. You can look at them. You can ask yourselves, well, if there was this struggle, where are the markings? Where's the bruising? Where are the scratches? Defense exhibits B through V will demonstrate that there were no such injuries. Let's talk about the cell phone usage on 9/2/2022. You know, the state would have you believe that Mr. Tellis's lack of responses to junk messages mean that he was occupied with murder. And through analyst Aguero, you heard, and you had the opportunity to see through the course of this gentleman's testimony, it was uncontroverted. We went through the messages during the key hours, the key times of September 2nd. The vast majority of those messages were automated. They were spam. How many of us respond to spam? It wasn't like he had every person reaching out to him, family, friends, repeatedly. Where are you? What are you doing? It's not. The vast majority of those messages were of no significance. They were junk. Additionally, the state did not establish a pattern of phone use behavior which would indicate that Mr. Tellis's communication activity on that day was anything different than his normal behavior. They had the devices, they had the access. You heard no testimony that his accessing his phone, his using his phone on September 2nd was anything different than the day before, the day following, the weeks before, or the weeks following Mr. Gehrman's murder. And let's talk about the deleted messages. You recall that was quite a big point that was underscored and argued through the course of testimony, and it was actually through Mr. Aguero, our expert, the issue concerning this deleted message. And you recall then we had the subsequent witnesses in the state's rebuttal that came forward with and it was through Mr. Tellis's testimony. Do you remember the watch, the Apple Watch? Then there was questions asked, what about the other device that presumably these messages were being received on? We didn't get the benefit, and again, it's their burden to compare the Apple Watch with the Pixel phone. We didn't have that. But what we did hear from that detective is that he couldn't say one way or the other. Do you remember that question, where are you? Obviously, if someone's home, they can speak with one another. But we didn't hear and we couldn't hear any evidence. And for you to just make a judgment based upon their own expert, their own witness who has special training and knowledge, say, I couldn't say one way or the other whether that message was deleted on the Pixel device, the device that they have alleged was Mr. Tellis's phone, that's significant. Let's talk about what the state does have. They've got a cut-up straw hat and shoes. There's really no reasonable explanation, rational explanation one way or the other. Obviously, if this person's the murderer, why not get rid of the shoes? You'd have to presume that he had knowledge of the shoes and their whereabouts. Let's talk about that hat. Why wasn't that hat discarded? Again, we'd have to presume knowledge on the part of Mr. Tellis where that hat was. And again, neither the shoes nor the hat tied him to Jeff Gehrman's residence. We had a shoulder bag with balls in it. Do you recall that exhibit? We had a basketball and a football that looked like some sawdust, and you'll have all of these exhibits. What's going on with that? I guess you're to use your common sense, which is one of the latter instructions, and assume that this bag is somehow implicated in the murder of Jeff Gehrman. And then it winds up in a storage area in the family home with a basketball and a football and what I would submit to you looks like sawdust in the middle of it. The image artifacts from the cache of Robert Tellis' phone, as well as the vehicle and the address inquiries on Mr. Tellis' work computer, it was fairly clear through the course of the testimony that that work computer had access to the Google account that would presumably be accessed by his Pixel phone. If one has password to that, one can have access to the devices. Matt Havaness said that he could not say the date of the cached images on the files of Mr. Tellis' Google Pixel phone. We were shown a calendar. We were to draw inferences. We don't know specifically who accessed, who searched for those images, and we don't know when they were created. And I would submit to you that that's significant, and the state should explain that to you. On Defense Exhibit 03, Robert Tellis' user accounts on Dell Omnipex located the Public Administrator's Office. Again, this is the report. You have it. This is Mr. Aguero's summation of his analysis. Again, it shows that this Google account, where these damaging photos and images are shown, it's the same. It's the same account. It can be uploaded, accessed by both the cell phone and the work computer. Obviously, we know what was going on from the testimony of multiple witnesses, what was going on at the Public Administrator's Office and the turmoil. I would submit that's something that you should consider and determine what the facts are and what the state has proven beyond a reasonable doubt. There is a positive DNA hit for Mr. Tellis related to Jeff Gehrman's fingernails. And you recall at the beginning of the state's presentation last week, you heard from the crime scene analysts, and I would submit to you that it was fairly clear that there was a little less than an airtight investigation because, after all, police officers, detectives, crime scene analysts make mistakes. Reference to the lab techs, Ms. Brown and Ms. Koljenovich, they were trainees at the time that they did this DNA collection and the processing for presumptive negative or presumptive positive blood evidence. This is significant. It was Claire Manning. She had testified she was young, blonde. She had testified that she couldn't recall who bagged the hands. That was at the scene of the murder. You never heard testimony as to who initially bagged the hands of Jeff Gehrman's body. One would think, and common sense would dictate, that they'd be able to tell you that. They couldn't, not from a single witness. She testified that she took custody both of the fingernails and the evidence concerning Mr. Tellis, but again, she couldn't tell you who bagged the hands. Again, this Google search on the recipe, you heard that the last day of trial, like that was somehow significant. Do you recall in the recross of the detective, there was at least 2 computers at the Tellis home that were not reviewed. They weren't checked for those recipes. So again, I'd submit to you, we have a wash. Detective Mogg, Christopher Mogg, he's now retired. He's an analyst, he lives in Texas. You recall at the beginning of this trial, he gave what appeared to be fairly detailed testimony concerning the whereabouts of the subject, Denali. Do you recall on cross, it was addressed that at 9:10, that vehicle was entering in from the Piggott Elementary. And again, you saw the map. It's in evidence. You can see that this right here is not the entrance to Mr. Tellis's neighborhood. It's streets away. It's not close. He gave you testimony that apparently he drove through the neighborhood where Mr. Tellis lived, off the Spanish Steps address. He said to look for things of evidentiary value. We heard nothing. We heard nothing concerning other vehicles in the neighborhood. Do you recall the testimony that there was at least 67 red Denalis? We heard testimony that that number at one point perhaps was greater. Perhaps it was at 67, which nobody contradicted, but we never heard what it was ultimately narrowed down to. We had Detective Mogg, and I'll refer to him as detective because in essence he still is. He testified and just said he was sure that it was that man's Denali, period. Do you recall the testimony that was shown concerning, and I would submit to you because you are the sole judges of the facts, that there was something peculiar about this Denali, something in the right-hand window area, that plastic stripping. You have the photos. Please look at them. We are given testimony, and based upon his analysis, we have at the same part near Piggott Elementary, we have this vehicle leaving at 9:12:32. But what's significant about the 9:10, where we see it entering the neighborhood or the area, again, it's not Mr. Tellis' specific neighborhood, we're not told where it was before that, who was driving it. What's important, and I want to back up, is at 9:10, we have this vehicle entering the area. And you have to ask yourself, what's occurring between 9:10 and 9:12? If we're to take the state, based upon the evidence that they have presented, what went on during that 2 minutes and a few seconds? We don't know. Did it even make it to the Tellis' house or some other neighbor, other house in the area? But as to the 9:10, it's important because it's the state's theory, and we heard it argued that Mr. Tellis left his phone. Well, we have, and this is Defense Exhibit A3, we have that phone receiving messages. Look at the times, all throughout the morning. We have that phone receiving messages 7:44, 7:45, 8:47. You can see, and this will be given to you. It's close to the cell tower next to Mr. Tellis' home. So then you have to ask, well, where was this vehicle? And I'd ask him specifically, did you follow this vehicle? Did you see this vehicle prior to the 9:10 time taken from Piggott? He didn't. But we can see, based upon the evidence that was provided to you by the defense expert, that phone is in the area all that time. It's in the Spanish Steps area. So obviously the argument, and I would submit to you, common sense would dictate, well, if that is going to Mr. Tellis' home and it's not arriving in that area until 9:10, why do we have all of these other pings at all of these other times close to the home, if not at the home? He laid out very specific detail, and he had talked about this approximately 5.3 mile trek that he wants you to believe was Mr. Tellis' vehicle, and that vehicle was occupied by Mr. Tellis. His video analysis takes 2 hours. It covers 2 hours and 39 minutes. The state couldn't show you what happened during that 2 hour and 39 minute period. 5.3 mile trip to and from. They basically show you closed circuit TV coverage, which it wasn't. There was a lot of dark spots of the vehicle driving there. But then the vehicle driving back, and I won't say it was driving to and from Tellis' home because we have no evidence of that. We're to believe the state that there's no ring cameras in a fairly affluent neighborhood. I'd submit to you, does that make any sense? What we're going to ask you to look at, and please do, you know, you've done a lot through the course of this trial. It's your duty to be here, and you have fulfilled that duty. You've taken notes. Through the very last witness, it's been apparent that you've been paying attention, that you've maintained an open mind. You know, oftentimes we suffer, especially law enforcement, from what's called confirmation bias. You reach a judgment, sometimes early on in the case, and then you work backwards to confirm what the judgment that you've arrived at the beginning should be at the end. And I would submit to you that that's what happened. This was the 1405 wintergreen. As you recall, there was an issue concerning the timing. This was channel 3, all right? This is State's Exhibit 372. You have that. You'll be given a laptop. Look at this. This was an image that was not part of his presentation to you at his testimony and during his testimony. This laptop has the ability to pause. It has the ability to zoom. Watch this. We're going to slow this down now. You have this evidence. It wasn't part of his presentation, but it's been provided to you. Look at the profile. What's that look like on the top of the head? I'd submit to you that looks like hair. We've seen Mr. Tellis. He gave testimony from the witness stand. Does that profile match the profile in that vehicle? I mean, it's no secret. The man's bald. Look at the face. Look at the eyes. I'd submit to you that those look like glasses. And again, this is part of the evidence collected by the state. It's been presented to you. It wasn't addressed during their case in chief, and it wasn't explained by Detective Cliff Mogg. I'd submit to you, look at that image. There's hair. There's glasses. Now, the state in rebuttal, and we'll address the significance of that, they have the opportunity to come and address what I've presented to you, but that's undeniable. What I'm going to show you next is the image on channel 2. That's the same video coverage, but now it has the vehicle coming from a different direction. It's parked. Do you remember the testimony from Mr. Martinez? I think it was John Martinez. Of no significance. It was fairly unmemorable on that date. He said he saw the person. Nothing caught his attention because nothing was memorable. There's no talk of a disguise. Glasses, nothing. It's bland. Nothing was memorable. Take a look. Oh, hang on. That's Mr. Martinez that I had discussed. Look at this image. Look at the profile. It's hair. We have two captures from two different angles. The profile does not match the profile of Mr. Tellis. And they're consistent. It's not open to dispute. You know, you've heard testimony, and you heard it primarily through Mr. Tellis. You heard it from Nicole Lofton. Mr. Tellis was fairly concerned about the goings-on with Compass Realty in relation to errors, in relation to the trampling upon the legacy of errors by the mismanagement of the properties that were left through intestacy. I would submit to you that Detective Jappy inserted himself into the murder investigation. And again, I want to draw, a couple of arguments from this Compass Realty testimony. I mean, we know that Mr. Tellis was very concerned about Compass Realty. He was the whistleblower. He was concerned about the actions of Compass Realty. You know, during the 2 years that he's in custody, I mean, what would a man do? He's fixated on that. He's ruminating on that. I would submit to you that common sense would dictate, and your experience would dictate, well, he's going to focus on the involvement of individuals who he was focused on prior to his being arrested. I mean, really, what are his alternatives? And again, this goes back to the burden on the state and not the defense. What can he really do when he's locked up? He's going to focus on Compass Realty. It's easy to dismiss him as being crazy. Oh, that's Looney Tunes. But hey, he's been in custody for 2 years. He was worried about Compass Realty prior to being incarcerated. He was worried about the goings-on with the old guard, about his work at the public administrator's office for financial reasons. He testified concerning, and you've heard testimony supporting that. Why wouldn't he continue worrying about that? Why wouldn't he keep thinking, well, I'm being framed, I'm being charged with a murder that I don't think I committed, I didn't commit. He's going to focus on what he was focusing on before he was arrested. You know, we heard testimony from Detective Gaddis. Do you recall the exhibits, the information that was presented about the release on September 5th? The video release of that individual walking. They started getting tips. Do you recall the email that was in her 70-page officer's report where she had communicated with Detective Jappy predating that? The first communication that we have on record and that's referenced is September 4th. Detective Jappy, when asked, did you incriminate him? Did you give him, did you give her evidence implicating him in this crime? And he said, I gave her information. But then we heard from Detective Gaddis that she had a communication with him again on September 5th. And again, she was given motive. In Detective Jappy's mind, she was given motive to focus on that man and his alleged motive to kill Mr. Gehrman. So he wouldn't agree from the stand that he implicated Mr. Tellis, but to call a detective or to email a detective on September 4th, and then again on September 5th and say, look at this guy, he's got a motive to kill. How could it be anything but an implication? You heard crime scene investigator Baxter. Her testimony concerned the goings-on at the public administrator's office during the execution of a warrant on September 8th of 2022. Her testimony, and it was adopted by Detective Gaddis, she stated Mr. Jappy, she said Detective Jappy, was taking his own photos and collecting his own evidence during the search warrant at the public administrator's office on September 8th. And it wasn't a mistake, because it was asked to her on cross, and it was confirmed what she had said before you, the sole judge of the fact, by Detective Gaddis, the primary detective concerning this homicide investigation. We had heard testimony that Mr. Tellis, as a result of the warrant obtained by Detective Jaffe on August 17th, 2022, that man was under surveillance. It appears until Detective Jaffe inserted himself into this investigation, we had dual investigations, a short one and a much longer one concerning Robert Tellis. We know from Detective Jaffe's testimony that he was exonerated. There wasn't this kickback scheme. He had been implicated by an agent who was a real estate agent who was a detective at the time. That provided to Detective Jaffe in part the probable cause to get that warrant. So we have a member of Metro giving another member of Metro evidence, testimony, opinions about a kickback scheme implicating Robert Tellis. We also had heard through testimony that Compass had a direct line into the Public Administration Office. And again, I discussed Mr. Tellis as being incarcerated because I would submit to you it's understandable why he believes there's this wide-reaching conspiracy. What other options does he have in his circumstances, under these circumstances? We do know that the District Attorney's Office refused to pursue action against Compass Realty, and again, I'd submit to you that that's significant. You know, the purpose of closing argument is for counsel to stand before you and highlight the evidence that's been presented to you. I'm not going to stand here and go through every witness, discuss every piece of evidence and all the testimony because you have been here. You have been attentive and you are fulfilling your duties. You're being good jurors. But again, my job is to argue the law and, in essence, the facts to you and what we feel is significant. As I said at the beginning of my remarks, it's the state's burden, and the state's burden alone, to prove this case beyond a reasonable doubt. This is our last opportunity to discuss matters and discuss the evidence and the inferences to be drawn from the evidence. Mr. Hamner now is going to take the floor and he's going to argue concerning matters that I perhaps didn't bring up. Address those on your own. Look at the evidence. You've got over 36 exhibits that were marked and admitted through the defense in this case. Watch the videos. Look at the drive concerning those images of that gentleman with hair, which Mr. Tellis does not have. But since the state carries the burden and the state alone, they get the opportunity to get 2 bites of the proverbial apple. Mr. Hamner now can stand and argue why you should convict Mr. Tellis. And I'm going to ask you with your open minds and your attentiveness to address those concerns. And at the close of this process, you find Mr. Tellis not guilty.
Thank you very much. Mr. Hamner, you may begin your rebuttal.
Yeah, if I can just get a minute just to set up.
Sure.
Okay, thanks so much. I'm not going to be further than that. Thank you. That actually, well, it needs to be plugged into my laptop. That's fine. I don't want to do this. Does that roll on? Everybody hear me okay? All right. This is quite the setup. Okay. May I proceed? All right. Well, it's been 2 weeks. You guys have heard a lot of evidence. We thank you for your patience, and I will try to be as brief as I can. But as you've seen, with witness after witness after witness, the evidence is absolutely clear. The defendant murdered Jeff Gehrman. He murdered him because Jeff's writing destroyed his career. It destroyed his reputation. It threatened probably his marriage, exposed things that even he admitted he did not want the public to know. And he did it because Jeff wasn't done writing. He was informed on August 8th that a records request was being made by Mr. Gehrman long after he had lost the race, well into his lame duck remaining administration as a PA. And he learns that Jeff wants to write more. And when he learns about the subject of it, it's not about him and Alicia. It's not about him and Rita. It's not about anybody except him and Roberta. And what you see unfolds over the course of a month. We learn from his phone expert that he shut off all location data, even though that phone, as we learn from his expert, 13 years of location data magically disappears for the month of August. Why? Because of the August 8th email. He's over it. He's building a reconnaissance case. He starts to go on to Google Maps. He starts doing surveillance at Popeyes. He's using the power of his office and their computer software to find private details about Jeff, so it can culminate in murdering him. And that's what he does. But as I've told many, many juries, especially in the last few years, it is really, really hard to plan the perfect murder in the digital age because you leave too many breadcrumbs behind. And he's no dummy. He's actually quite smart. He is thoughtful. But you will see during this rebuttal, there are mistakes that he makes. And there are things that he simply cannot account for that when a police starts to look into an investigation and deploys the tools that the police have at their disposal, it uncovers the inconsistencies. It uncovers his mistakes. But I gotta start with what he got up and told us about, the alleged conspiracy. When Mr. Tellis got up here over the course of, I think it was 3 days and testified, it was remarkable what he had to say, and not in a good way. His testimony was incredible, and not in a good way. He explained, or at least attempted to, explain this conspiracy. What we learned over the course of the 3 days, and actually the course of this trial over 3 weeks, is the conspiracy grew, and it grew, and it grew. Who's exactly in it? It starts with Compass, nebulously Compass Realty. We learned that Adam Fenn can't be ruled out, right? Because he makes donations to Rita Reed. Cindy Sauerland gets mentioned at one point. In some of those briefings, you'll see her name is mentioned. She's a source of consternation for the defendant. It expands to the old guard, as they coin that phrase. Rita Reed, Alicia Goodwin are all part of this, right? The conspiracy, and let's remember, it's a conspiracy to murder Jeff Gehrman. We then learn it expands to Derek Jappy. He's in on it as well. When he testified, he's not really able to link up why Derek Jappy would want to help Rita Reed or Alicia Goodwin or Compass Realty or Adam Fenn or Cindy Sauerland. That testimony is lacking. A lot of times when I pressed him, and I pressed him, and I'm going to explain to you one of the reasons why I cross-examined him so hard. When you stand on the stand under oath and you make allegations about businesses in our community, government service workers, and the police department, we deserve answers. I genuinely wanted to know, how is all this connecting? Explain it to me. And respectfully, Mr. Tellis absolutely failed in doing so. It didn't make sense. And that is one of your instructions, which is to use your common sense. It's got to make sense, and it actually has to link up with evidence. But a lot of times, the most common answer I would get back from Mr. Tellis was simply, well, no, I never saw Jappy take a bribe, but I think that. It was a lot of times it's like, that's just my gut feeling. That's my opinion. That's not evidence. That is not evidence. But yet, it was Mr. Tellis's answer for almost everything when it came to this conspiracy. But let's continue. It stretches out to include Cliff Mogg, Justine Gaddis, the entire DNA lab. He said there were also patrol officers in it. I asked him which patrol, I don't know which ones. And then it literally culminates with Steve Wolfson, like the DA. It culminated with him. He can't quite link it up, but he threw that name out there. And here's the thing that struck me when I took over this case. I would submit to most people, probably before ever hearing about this case, had no idea what a public administrator was. He is not a U.S. senator. He is not a governor. He is not a congressperson. He is a duly elected official who manages an office of approximately 8 people. And their job is to assist people who pass away, who don't leave a will and leave property behind. The public administrator's office is not at the forefront of everyone's mind in this community. No one learns about this until who brings the office to light? Jeff Gehrman. And what's amazing is if you believe that story about this conspiracy, all of these people and all of these entities were willing to sacrifice their reputation, their business, their police department, even the public administrator's office. They're all willing to put it on the line to kill a reporter, to get that guy, even though he's leaving in 3 months? Does that make a shred of sense? Absolutely not. But what it does give you a window into is what's in his mind. That is how important Mr. Tellis views himself. That every single one of these people, every single one of these entities were literally willing to kill another human being who is not him just to frame him. Does that make sense? And more importantly, where is the evidence to support that? Where is the evidence that you received in this trial that supports that? And the answer is you didn't. There isn't any evidence of that. Why would Compass conspire to frame him? Why? I asked him. I wanted to know. He couldn't give a good answer. His best answer was, well, I was going to do a lot of work in the next 3 weeks or next 3 months. Has anyone ever heard of any sort of legal filings, lawsuits getting settled up in a brief, tidy 3 months? That's not a thing. That didn't happen. That doesn't happen. There was no need to frame him because they already succeeded getting him voted out of office. And all they had to do was donate a whopping, at guess, 15 grand at best to get him out of office. They didn't need to kill him. He was on his way out the door. He is a lame duck. And lame ducks don't matter. What incentive does Metro have in this conspiracy with a real estate company to frame a lame duck? That's an even bigger one. Why would they do that? What did we hear that would show us that Compass is like, hey, guess what? Hey, Metro Homicide, we need you to join us to go frame this outgoing politician. I mean, we killed the reporter. That's not important. But I want you to join us in this, and let's go frame this guy. And all of Metro's like, sign me up. Sounds great. Does that make any sense? Absolutely not. It makes no sense. And it's not supported by the evidence. And again, if Compass is literally willing to kill, why not just kill him? Just kill him. Why does Jeff have to suffer? It makes no sense. And it gets even worse. Well, before we get to that, here's the thing. When we go back, when you think about the Compass question, right? Isn't Compass in cahoots with Rita Reid and Alicia Goodwin, right? They're funding Alicia Goodwin, right? Or no, Rita Reid. They're funding her campaign against him. And who do they get to help write the story? Jeff Gehrman. Like, why would they kill the guy who wrote the stories that got this guy out of office? Why would Compass do that? That doesn't make sense. And then, yeah, if it's really a frame job, the murder weapon should have been in the house. The orange shirt should have been in the house. The DNA should have been all over the place. Like, they're claiming, you know, well, why weren't these things located? The state would submit to you, he got rid of them. He got rid of the murder weapon and the orange shirt. He cleaned the outside of his Yukon. He even admitted it. And here's the thing. We only know that he wiped down his Yukon because on that one particular day, he was being watched. He wasn't watched every single day after the murder by Metro. Did you hear that testimony? There were other days he could have wiped the interior of his car if he wished. And I've always thought about the shoes. Like, the shoes to me was kind of an interesting one. My co-counsel's right. Like, the only one who benefits of like chopping up the shoes is Mr. Tellis. It's this awkward, amateurish way of getting kind of rid of the evidence. But I thought to myself, maybe Mr. Tellis didn't even think to like bring an extra pair of shoes. Because like, what happens if he walks in and he's totally barefoot? His wife would be like, why do you have no shoes on? He probably had to bring his shoes back in. He doesn't need the orange shirt. He doesn't need the murder weapon. It is his kid's bag, right? I mean, he said that's my kid's sports bag. So like, he probably needed to bring that back. I'm not sure what he was doing with the hat, I'll admit. But clearly he's chopping it up to try to get rid of it, just like his shoes. And why kill Jeff? Like, this is the question that is so destructive to this defense. It's his writing that shines a light on his behavior. He is sought out by the co-conspirators. to do this. And he admitted on the stand, one of the rare times he admits it, he admitted, yeah, his writing was the difference in the election. That's why I lost. I got that out of him. He was at least willing to concede that. But for Jeff Gehrman, he's still a public administrator. His writing is why the defendant is out of the job. And therefore, under this theory, he's got to be the one who's killed. That's his reward. He's collateral damage. Like, really? Rita and Alicia are like, sorry, Jeff, you got to go. It's been really nice. Thanks for the help, but you're out now. We got to clean up loose. I mean, is that really what's being suggested here? And the answer is that is what he's suggesting. But it defies common sense, and it's not supported by the evidence. And here's the other thing. Jeff's putting together a fifth article. And now, what we can tell from the records real quick, it's just about Roberta and him. It's the salacious stuff. So who in this realm, if you think about everyone in the conspiracy, and you think about Mr. Tellis, who is the one that wouldn't want another article written about him engaging in an affair? You think Derek Jappy cares? Cliff Mogg? Adam Fenn? No. It's him. He's the only one that would have a stake in making sure that article never got written. No one in the conspiracy would want to prevent that coming out. Especially not the Rita Reeds and the Alicia Goodwins. If they want that exposed, I mean, they went to have that exposed. They wouldn't want that being not put out. And I'm sure Compass Realty wouldn't either. I'm sure they would have wanted him discredited. Like, another article would, in theory, be great. They wouldn't have killed him. And then we have his walk. Like, he's got a little hitch in his getup, where he kind of leans to this one side. You can kind of see it. There's something that is about his little walk. And look, you don't have to take my word for it. You can evaluate whether you think what Zach and Christy had to say about it. They've hung out with him. They've walked with him. They thought, and think about how they saw it. They were like, man, they kind of knew the background between Gehrman and Tellis, and they were like, wouldn't that be funny if that was him? He's got those same goofy gray shoes. Like, that was the thing. Like, they noticed the shoes, which I think is really interesting, you know? But they don't act on it at first. But it's only when they see the Yukon that they kind of flip out and they're like, well, we probably should call on this. The only other person who came and said that wasn't him is Nicole. And listen, you'll have all of Nicole's texts. The state would submit to you that, look, there is no doubt she has a kinship to Mr. Tellis. You can see it in the text messages. You can see it. You can go read through them. The state would submit she has a bias. And, like, she cares about him. And I think he was probably good to her in the office, which is understandable. But look, you can judge it on your own. You can judge the testimony of those other people. You can make that call for yourself. But I would submit to you, when you look at this, think about all the other evidence in the case. Think about all the other evidence, the motive, the physical things found in his house, his DNA underneath the nails. When looking at this and being like, is that him? And the state would submit to you, when you put all that together and you watch this video, absolutely, it's him. Professional killer versus amateur killer. Mr. Tellis would like you to believe that this was an assassin with combat training. The state would submit to you, you don't need combat training to stab people. You don't have to go to knife school. You don't have to do that. If you're angry enough, you can stab people pretty good. If you got enough hate in your heart, you can really go at people. And I would submit to you, the state would submit to you, that Mr. Tellis had had enough of being exposed, written about, publicized, embarrassed, and he wasn't going to have it done again. Because at this point, the state would submit, Gehrman had taken everything from him. Everything. Everything that he worked for. He worked his way up through law school. He got himself elected, and this guy took it all from him. And so he wanted to take something from Jeff, and that was his life. Professional assassins don't use their personal vehicles. They don't use their personal phones or work computers to conduct reconnaissance. They don't wear attention-grabbing outfits. They don't flee the scene and then double back to pull right up to a murder scene to look for possibly dropped evidence. And they don't leave items of clothing or apparel they use in the murder inside their own house. Professionals don't do that. The state would submit to you that what this was an amateur attempt by Mr. Tellis to pull off this killing. But here's the thing. It is thoughtful. It is deliberate. He really did a thoughtful job about it. I give him credit. I give him credit. But in the world of the digital age, we leave behind too many breadcrumbs. And when you're not a professional and you are an amateur, you tend to make mistakes. And that's what he did. For example, really smart idea. He knew about IDI Core. Hey, I've got a really easy way to look up personal identifying information on people. I'll use my work computer. But what does he not realize? That we can, as the police, download the computer and literally see your keystrokes. How could he have known that? He wouldn't. It's an oversight. It's a mistake. It's a slip. And it's evidence that we collect against him. What else? He does the Google Maps surveillance. Really clever. What an easy way. You don't even have to go to the neighborhood. Just pull it up on your Google Maps. He does the Popeye surveillance. He takes the photos off of his work computer, right? But he forgets to delete his cache files. And let's just make this clear once and for all. Matt Hovanetz told us what? He said that these are not created photos. They would say created in a date and a time and you'd have it. Those don't exist on the phone. I wonder why that is. Why do you think there aren't all those images? Forget the Google Maps surveillance, right? That's just, those are probably images that the program pulls up. Sometimes it's referred to as tiling. But like the Popeyes photos, which are coming from the phone, and the one from the work computer, why don't we have any created photos? The state would submit to you that Mr. Tellis, being the smart guy that he is, the techie, as he describes himself, deleted them out of his photo album. But the problem is, he didn't delete his cache. And we learned from Matt Hovanetz that the caching of photos is what happens. The example that we heard was, say you want to send an email, and the computer will shrink down the actual image to get down data size lower so it can go out. He didn't delete the cache. He deleted the actual photo, but not the cache. And so those dates tell us that essentially in the month of October, he is doing all of these things. He tried to get rid of it. He couldn't get rid of all of it because he's an amateur. He conducts reconnaissance in August, but doesn't realize that the police are going to acquire the 8/8 email about the public records request, right? Like, did he really? Maybe he probably didn't realize that we would go into the PA's office and say, hey, we want what communications are out there, and we get the email. Now we understand the significance of why these things are all happening in August, because we get the email. He didn't account for that. Here's another thing. He shut off all his location services in August, but doesn't realize it's going to stick out like a sore thumb during a location services analysis. And here's the crazy part. His expert gave it to us. His expert said, I have 13 years of location data on this phone, but for the month of August, it's a 0. It's a bagel. Why? Why that month? Because it's right. It's when he's planning the killing. He knows he's going to those spots. He doesn't want to be tracked. He's no dummy. He's smart. But the problem is that is an electronic breadcrumb. An entire month, no location data at all for anywhere that he traveled. That was the testimony of his witness. And he didn't claim that that information was hacked or compromised. What else? He decides to wear gray Nikes, but forgets to delete the shoes off his phone. And then he fails to get rid of the shoes in time by the time the cops do the search at his house. Maybe life just kind of gets in the way, right? He's maybe doing it late at night when the kids are asleep and his wife's, doing a little, I don't know where he's planning on sprinkling the bits of the shoe, but like clearly he wants to do that to shrink it and maybe it's harder to find. Like he's putting it in a place that only he would find it, like underneath the recliner. And like, he can't account for like the one random photo where like his murdering shoes are right there when he's out rock climbing. Like, he can't plan for that. And all the hundreds or thousands of images are there. He can't plan for that.
creates the disguise of the construction worker, but it doesn't account potentially for an interaction. And then again, he leaves his phone at home, which is smart, right? So we don't see the movement of the phone kind of going with the Yukon, right? But the problem is that when you go radio silence for like 5 hours and you start ignoring your wife's calls and texts, that's a problem. And then, great example. He gets up here and he tells us the whole story about the chicken fried rice. He was so happy to share that story. I was making my daughter lunch because she doesn't eat the school lunches, and I cut the tip off and I started bleeding, so I went and got the super glue and I cut it and they got it. And so that's why the DNA, that's the one time he was fine with DNA. But like, he doesn't realize that all we have to do is start checking it. Is there a Google recipe for chicken fried rice on your phone? And there wasn't. Because that's what he said he was doing. He didn't just say I was making a meal, he specified how he was doing it. He was like using a recipe, and that's the most logical place you would do it. People are not bringing their desktop computers and putting it in their kitchen when they're cooking fried rice. Like, that's not how that's going down. Like, he was, if that theory story was true, and we would submit it as not, because it's not there in the phone, he probably would have sat there with his phone on the counter, hit the YouTube or the Google recipe, and then he's working. So it should be there. But it's not. Because that was something used to explain why in the world would my DNA be on the scissors. Again, another example. He goes to great lengths to park down the street. And then it all goes down the drain when he leaves because he realizes, oh, I probably forgot something. So he wheels back and parks right in front of the house. That's a huge mistake. It's an amateur mistake. Here's another one, and I just noticed it while watching it. He left the garage door open. If you watch the video after he does the killing, he walks away, the garage door is totally open. And then when he drives back and he gets out, he has 2 opportunities to close the door. What did we learn about what prompts the neighbors to worry about Jeff? It's the garage door. The hitman, the assassin shuts that garage door. But not an amateur, like Mr. Tellis, because in the panic of the moment, he's just like, I gotta get out of here as quickly as possible. It's a slip. It's a small slip, but it's reflective of who we're dealing with. And then he forgets to get rid of the hat. He forgets to get rid of the bag. He forgets to wipe his phone entirely. Next time, factory reset. Full factory reset. Hopefully that'll clear it all. Probably be up in the cloud. But the point is, he doesn't do the things he needs to do. They're amateur mistakes. It happens. But that's why it's hard to pull off the perfect murder in the digital age. And about that gray bag, the defendant told us on the stand he'd like to think he wouldn't have removed his children's basketball and football to use it in a murder. Remember that? And there's the bag. And there's the bag. And there it is. And the defense in his closing arguments said, we submit that there's sawdust inside the bag. Well, let's take a closer look at the sawdust. See that bag? Let's take a closer look. Remember the big sun hat? Is that sawdust? Doesn't look like little chopped up little bits. Looks more longer and rectangular and flat. Here's the hat. Here are those bits, long and rectangular. The state would submit to you, he put his chopped up hat in that bag and then transferred the bag into the Sprouts bag, put the basketball and the football back inside. That is not sawdust. I want to touch on some things that were brought up in closing argument. That Garen's DNA is the only one at the scene. Well, our response is, well, his DNA is underneath Garen's nails. So that's a huge problem. Not in his vehicle or in his clothing. He got rid of his clothing. We'd submit he cleaned his car. He also wasn't surveilled 24 hours a day. There was no positive ID from him at the scene. And that is correct. And listen, that's why we have this instruction about direct and circumstantial evidence. Because in Nevada, the law doesn't make a difference between the two. You can weigh it as you wish. Some cases have incredibly powerful examples of circumstantial evidence. Sometimes you've got a combination of both. Sometimes it's all direct. But
but there's tons of direct evidence, like him in the Yukon, like that's to be tracked from literally Silk Tassel all the way to his house and then all the way back is incredible. You heard about how many officers it took to track and go business to business to business to business. That's direct evidence. You've got the circumstantial evidence of his DNA. You've got the shoes with his DNA in it that's chopped up. You've got the hat. You have the surveillance in the phone. You have the whole motive laid out from the articles. I mean, okay, you're right. We didn't have one person standing out going, I watched Mr. Tellis stab Mr. Gehrman. You're right. But we got a whole lot of other evidence. There's no surveillance of Tellis exiting his home. You've heard testimony about it repeatedly. There wasn't cameras in the area. We just have surveillance of the street that's perpendicular to his driveway. And I thought I had pulled up, maybe I didn't, I apologize. I tried to put the image of that, but I want to address that. It might be still in here. Go back and check the map. Because the way it actually works is Piggott Elementary, when he's coming in and out in his red Yukon and going to the gym in his BMW at the end, the street that comes down perpendicularly to turn out along the Piggott Elementary, that street is Silk Tassel. And when you look at a map, if you follow Silk Tassel, it perpendicularly, it runs into his driveway. Like all he has to do is like drive out of his driveway and he's already on Silk Tassel. So you're right, like we don't have him getting out of his car from his driveway, but we literally have the only street he needs to take to get to Piggott Elementary. It is not streets and streets and streets. It's the street before his driveway. There's the argument, well, Metro makes mistakes. There's that deletion of a traffic center. Well, as I've just pointed out, Tellis made a ton of mistakes himself. So we will own that, you know, on one traffic stop, we didn't mark a proper event number. And you can give it whatever weight you want. Tellis cutting himself while cooking. You know, again, we've talked about the chicken fried rice thing. That's not backed up. Wouldn't there be blood from the cut? Not necessarily. What if he had gloves on? And he's kind of cutting his tip. It may not be pouring everywhere. And again, look at that scene. The majority of the blood of Mr. Gehrman is actually just kind of pooling from where he's resting. It's not splattered all over the house walls. It's not that type of scene. I mean, Gehrman's shoes are such a good example of that. Like, he's the guy who gets killed. He's the one stabbed 11 times, and his shoes are relatively clean. And he's not doing a lot of walking. A lack of responses to junk messages. That's true, but there are work messages he's not responding to, and his wife is reaching out to him, and he ain't responding for hours. That's a problem. That's a problem for him. Especially, go look at, when you're not in the murder window, go look at the communications. So like when his daughter reaches out to him in the morning, he responds like that. No issue. Like at 3 o'clock or so, or 2:30, when Tonya, his ex-wife, responds with a question about the kids, he responds immediately. And what did he tell us on the stand? What did he tell us on the stand about being at Summerlin Area Command? What was his big worry? My family doesn't know where I am. I was so worried about being detained there because I couldn't reach out to my family, because that was the most important thing. And what do we know on the day of the murder in the murder window? His wife wants to know where he is, and he's not telling her. That is significant, because his pattern is, when you look outside the murder window, he promptly responds to family members about family matters. But he goes silent with his wife when he's literally in Mr. Gehrman's neighborhood. And another thing, remember his face when I showed him the Apple photo for the first time? If anybody remembers, store that one away. Because he was very comfortable on direct talking about the timeline. And he had his story all lined up. And when I showed him the photo, the message that wasn't there, that face really changed. And you can weigh that when evaluating his credibility and his responsibility for this.
And then there was the argument about DFL analyst Hovannes couldn't say one way or another if it was deleted. Well, you're right. He's like, I can't definitively say it. What he does say is, I can see from the photos the message is there. I can see in the timeline it's not there. Sometimes there are situations where people delete things deliberately and it's marked as deleted, so it'll appear in an extraction report. But sometimes people delete messages and it's not. But he can't definitively say for certain. So I would submit this to you, ladies and gentlemen. Look at all the surrounding evidence in the case. And then you can reach a conclusion about this. Because, ladies and gentlemen, circumstantial evidence is a chain of facts that lead you ultimately to a conclusion. It's like connecting the dots. And so if you're wondering about this, look at the phone evidence. Look at the motive. Look at the physical evidence in his house. Look at the timeline of when he's gone. Look at when the Yukon is where it is in relation to just nothing is going out on this phone. And then you decide, you can make a call about whether, and his manner on the stand, listen to him testify, and then you can decide whether he actually deleted that message. And I'm going to get to the significance of why maybe that message was deleted in a bit. And again, claims couldn't tell, Hovannes couldn't tell you the cache date on the phone. The state would submit, and you can check your notes, that's not his testimony. He never said, I can't tell you the cache date. He said, I couldn't tell you the creation date. He said, the cache date is something different. That's what the report is showing me. That's the last time this image interacted with the phone. So that's the time that those smaller images are interacting with those phones, all those dates in August. Not bagging the hands. And that was an argument being made. Like, no one could tell us exactly who. So I would say, what means what? Has there been testimony that the DNA evidence was compromised? There was no evidence of that. What is being asked of you? You're being asked to speculate. And you have an instruction on reasonable doubt. And reasonable doubt must be actual, not mere possibility or speculation. Speculation doesn't get you there. It's improper to speculate. Ah, here it is. I knew I didn't forget it. Colin was streets away from his home. That's not correct. That's his house. This is the road. When you're watching that Yukon come in and out, and his BMW coming out, this is what you're seeing. So you're right, we didn't get any homes in this area with camera footage. But we got about 5 miles worth other than that. There was an argument, does it make any sense that there aren't any other cameras in the neighborhood? And my response would be, did you see Mog's presentation? Does this appear to be a case of Metro's not interested in collecting video? There's like 28 sources. The state would submit to you, if there was a camera that was working, that was closer to his house, they would have gotten it, and we would have wanted it. And then there was the video that they showed of this other car, right? With someone presumably with hair and glasses. The state would encourage you, by all means, go compare it to the rest of the videos. Compare it to the rest of the videos. And compare it with all the other evidence. And then you get to weigh it. Because we did hear from Mr. Martinez. What did he also say was going on in that neighborhood? There was a 7-day-a-week, 24-hour construction project where they're repairing a sewer line. I asked Mr. Martinez, what did you guys wear? We wore orange things, right? And in that video of that car, there's someone in an orange thing. Is it possible that that's one of the workers from the sewage project? He seemed to be coming down the road in that first video. He's coming from the road where Mr. Martinez said he was waving people off, remember? Martinez said, I saw that when we saw the first video, right, of the car approaching and the white truck pulls up, he said he was going out there to tell that person, you can't come down this other way. And the video that the defense shows you shows a car coming from that other way. And if we marry the testimony of Mr. Martinez, the state would submit that's the construction area. In all likelihood, that's just another worker. But you get to weigh it. You get to weigh it with everything else. Then there's this argument about Jabby mysteriously inserting himself in the homicide event. Really? Is that the testimony? Detective Jabby told us that he had to attend the Metro briefing that night. Why? It makes sense. He's literally a detective that's working on an investigation on him. Does it make sense that Metro would want all people maybe involved or some kind of connection? Absolutely. But did you really hear a situation where he was injecting himself into Justine Gaddis's investigation? The answer is no. Detective Gaddis talked about contacting him from time to time, and when contacted, he either met the person or responded, but there really isn't any evidence of him interfering with an investigation. And then here's the other thing. There's testimony from a CSA saying he was taking his own photos and collecting his own evidence. What is the significance of this? We do know from Detective Jappy, he is conducting 2 investigations at that time for Compass and Tellis. It goes on until January of 2023. So is it possible he is collecting information tying to one of those? It's possible. But the better question is this. What evidence do we have that Jappy's presence being there compromised any CSA's collection of the information they needed to get? Did you hear a CSA say, like, he didn't let me pick up that computer that I needed to take? He didn't let me take Roberta's computer. Did you hear anything like that? That he was some sort of obstacle from the CSAs doing their work in the PA's office? The answer is no. So what is the point of bringing this up? It is an argument or suggestion asking you to speculate because there isn't any evidence that he interfered with their collecting of evidence at the PA's office. It's not there. And then the DA didn't pursue charges, and I would submit that was significant. That's what he said. Respectfully, the defense doesn't expound upon the significance. He just said it was significant, but doesn't expound why. Why is that significant? He never explains it. It just stops. And the state would submit to you the testimony of Derek Jappy is really significant because Mr. Tellis would have you believe that like he's being framed by Derek Jappy and his complaints about Compass are not being taken seriously, and he got up on the stand and Derek Jappy told you the exact opposite. He exonerated Mr. Tellis from what he was hearing from Reader Reed and people in the PA. He exonerated him. But he's supposed to be the head co-conspirator from Metro. Why would he exonerate him? And then he did go to the DA's office and said, I think we should pursue charges against Compass, and was told, listen, due to this loophole, it's not going to work. Like, you have inconsistent information about what these people are notified or not. And the court records do show that, Cindy Sauerland is identifying, when they want to file on this case or, notify next kin. Like, there's records that match up. So even it's just like, it's literally the exact opposite of what Mr. Tellis wanted to have uncovered by Jappy. And like, he didn't, if he really was out to get him, like, he should have just stopped when the arrest was made and we could be done. But that's not what he does. So I want to get to the defendant's testimony. There's a credibility instruction. You were instructed that you need to consider witnesses, and since he testified, he's a witness, consider his manner upon the stand. Think about what his fears, motives, interests, or feelings are, and the reasonableness of his statements, and the strength and weaknesses of his recollections. And then here's the kicker. Under Nevada law, if you believe a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of their testimony, which is not proved by other evidence. The state would submit to you that arguably, Mr. Tellis' testimony, he might have been our best witness. Based on his manner on the stand, based on the things that he said, he spent 2.5 hours on that first day, and almost 80% of it is talking about things he did in the public administrator's office. It's not about the actual murder or what he's doing on that day. He just wanted to regale you with all of his achievements as a public administrator and how he fought against people standing in his way. And the state would submit to you, as my co-counsel told you in opening statements, that's not what this case is about. It's not about whether he was a good manager or not. It's not about if he had an inappropriate relationship. This is about whether or not he had a motive to kill Jeff Gehrman, and did he in fact do it? And he did. Think about his difference in how he spoke to you on direct on a narrative versus trying to answer my questions. How many times did I have to repeat, sir, my question is this, bring you back to my question. Sir, I didn't ask you why. I asked you a yes or no. Think about that for a second. Because, and think about this. What are his fears and motivations in this point in time when he sits on that chair and he's talking to you? And we're going to get to something about that I think is very significant. And it's right here. He took the stand and he admitted on cross-examination that he lied during his May 11th, 2022 interview with Jeff Gehrman. I asked him, what was it the part that you were untruthful about? And he said it was about my relationship with Roberto. And he said, and I said, you know, he said, I didn't think the public should have to know about that. And it was really important to conceal that information from his family. This is really significant because what it tells you is that back in May, when he was facing just an election, he was willing to lie to protect his job and to save his marriage. Now, the stakes are even higher. They're far higher. So you get to evaluate, are the things that Mr. Tellis is now saying, is it possible he could be lying about some of those details? Because this is far greater than that. Think about the difference in his body language, his ease of sharing information. When I'd ask versus when he just had free reign to say whatever he wanted. They're like night and day. And the state would submit that the defendant's view of this situation is completely divorced from the evidence in the case. It's like he's talking about a thing that's, it couldn't be farther apart. He talks about these conspiracies, but he's so short on details. Always. Oh, he took a bribe. Did you see someone take it? No, I didn't, but it's just in my gut. I think that happened. That doesn't work. That's not evidence. Something in your gut, or I just feel it, that's not evidence. And when you think about it, it does make sense. Because if Mr. Tellis had to be honest about what the evidence is in this case, it's a very difficult thing for him to explain away. It's his DNA underneath the fingernails. It's his car that's there. It's his Google Maps images in his phone. He's conducting surveillance at Popeyes. He's using his computer to look up information on this guy. He's got these text messages explaining how upset he is about everything involving Gehrman. That's a huge problem. Because really, he's the only person who wants Gehrman dead. He's the only one. And really, this was kind of, in my mind, what jumps out to me. It's like a because I said so. Like when I pressed him on things, like why is this? Why is this? And it was just simply because that's how I feel. That's not evidence. And again, the defendant is also selective during his testimony about what evidence had been compromised versus properly collected. Great example was the scissors DNA. At the beginning, I'm like, the DNA in the fingernail, you couldn't get an inch out of him agreeing with that. I'm like, you at least agree with me that it's been planted, and he didn't even want to do that. But he had come up with a story about cutting his finger, so he's fine with that DNA being on the scissor. That's a nice contrast. You know, and he picked and chose, and you can check your notes on that. But that, to me, is really significant, because he was fine talking about certain pieces of evidence that he thought was good. Great example, the timeline on direct. He's happy to tell you his narrative on direct, because he forgets about the where are you. And then on cross, when I confront him with the where are you, now things are a little bit different. But he had no issue with anything in that timeline at first. And another thing, when the defendant testified, a lot of times he didn't use phraseology like, I didn't do this, or I didn't do that, or I didn't stab him, or I didn't go to that scene. It was never that. I mean, maybe from times he would say it, you'll check your notes, but the vast majority of the time, Mr. Tellis would say it like this. I'd like to think I wouldn't do something like this. I'd like to think that I wouldn't do that. I'd like to think I wouldn't take my children's sports balls out of the bag to use for a killing. It's an interesting phraseology. The state would submit it's a bit of a tell. Because he could have just simply said, I didn't do that. I didn't touch that bag. But that's not how he words his behavior. It's this like Monday morning quarterback. I'd like to think I wouldn't, because it's really bad. You can weigh that. when you're evaluating how honest and truthful he was when testifying. And again, for all his talk about being conspired against by powerful enemies, it's actually the defendant that uses the power of his office's proprietary software to spy on and discover where Gehrman lives and what type of car he drove. He used the power of the office, Mr. Tellis. And here's another thing. Remember the map that they brought up, kind of trying to show the drive from the PA's office to Popeye's? When you study that, remember it's Analyst Hovanet's testimony. Those reports out of Axiom from the work computer aren't converted for UTC time. So he was trying to use it to say, like, I couldn't have done this at this certain time. It's not UTC converted. And then we get to where are you? Remember, every single message between the defendant and his wife on 9/22 are on the timeline, with the exception of where are you. So here are the messages, where are you? Now they're talking about his daughter, collecting or selling things. Wow, that's incredible. There's a doctor's appointment. Are you at the doctor's appointment? No, we're at the barbershop. Okay. Then there's a text about the scheduling of the appointment, and then he also says picture week. All of that's on that Apple Watch. Oh, and also the deposited message. And then when you look, it's all the same stuff, with the exception of where are you? That's the one thing that's not there. There's the cards thing, there's that's incredible, at the doctor's appointment, the barbershop, okay, the appointment last week, picture day, and then the deposited message. It's all there except for where are you? So why is this significant? Number one, the defendant cannot answer this text or pick up her call because the phone is at home while he is murdering Gehrman. Number two, the defendant couldn't leave this message on his phone. Why? Because it would reveal that even his wife is looking for him at the time of the murder. And third, given the state of their relationship at that juncture, given what you've now kind of acknowledged what he was doing privately, if your wife calls and you have your phone on you, you're going to take that call. You're going to answer that text message. You're not going to let that sit for like 5 hours. No way. No way. Some final thoughts. I want you to think about this one. This is something I never actually asked Mr. Tellis on the stand, and I really tried to ask as many of these, but this one really struck me. The Las Vegas Metro, if the Metro Police Department, the Las Vegas Metropolitan Police Department, was really in on a conspiracy to get the defendant, right, to truly get him, here's a question for you. Why not let him die in the tub? You saw the video. Why not let that man bleed out? You had your opportunity, and yet they don't take it. Mr. Tellis' life is saved that day. And who ends up saving his life? Why, it's none other than the head conspirator from the Las Vegas Metropolitan Police Department. It's Detective Derek Jappy. He testified that he spent 2 hours on the phone talking him off this ledge. 2 hours. And then you got to watch the footage. They saved his life. If the conspiracy is really true, Derek Jappy doesn't do that. Metro doesn't do that. They literally let him bleed out. But that didn't happen. And the reason is, ladies and gentlemen, is because there never was a conspiracy. You made a commitment when we did voir dire to follow the law. The law in this case is abundantly clear. These 3 theories of liability are abundantly clear. He is guilty beyond a reasonable doubt on all 3 theories, and it's not close. And so we ask you to follow the law and follow the evidence. Do not speculate, but follow the evidence. As my co-counsel brought up, in the end, this is not a case about politics. It's not about alleged inappropriate relationships. It's not about who's a good boss or who's a good supervisor or favoritism at work. It's just about murder. And I want to end, if I could, just want to make sure that this is working, with something that Mr. Tellis said in his interview that really struck me. And I noticed it during the opening statement. And it's this.
People people just cannot get to do whatever they want.
And it's just that people don't get to do whatever they want. For once, the state of Nevada is in agreement with Mr. Tellis. He doesn't get to do whatever he wants. He took the life of an individual who was simply doing his job because he didn't like how it impacted him personally. Please hold him accountable for murdering Jeff Gehrman. Thank you very much.
Okay, at this time, the clerk will swear the officers of the court who will take charge of the jury panel.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed, so help you God?
Yes. Yes.
Okay, at this time, ladies and gentlemen, you're going to be excused. When you go back, you're going to have lunch. After lunch, our two alternates, Mr. Max Gross and Zachary Crayson. You will go with one of the court officers. At that time, the clerk will bring back all of the evidence, and you'll begin to deliberate upon your verdict. So when you're done eating lunch, make sure Officer Hawks knows, and the clerk will bring back the evidence. Thank you very much, and you're excused.
Thank you. All right.
Yeah.
to order and be seated, please.
The record reflect that the hearing is taking place outside the presence of the jury panel. The court has marked as Courts Exhibit 27 and 28 notes received from the jury panel. Does the state want to say anything?
No, Your Honor.
The defense?
No, Your Honor.
Okay, at this time we can bring the jury panel in. You can bring the jury panel.
Yes, ma'am. All rise for entering jury. Thank you, everyone. Please be seated.
Does the state stipulate to the presence of the panel as well as the two alternates? Yes, Your Honor. Mr. Jaskowitz?
Yes, Your Honor.
Thank you. Juror number 2, have you been selected to be the foreperson?
Yes.
Has the jury reached a verdict?
Yes, we have, Your Honor.
Will you please hand the verdict form to Officer Hobbs? Okay, the clerk will now read the verdict form out loud. The defendant and his attorneys will stand for the reading of the verdict.
District Court, Clark County, Nevada, State of Nevada, Plaintiff versus Robert Tellis, Defendant, case number C-368935, Department number 12, verdict. We, the jury in the above entitled case, find the defendant, Robert Tellis, as follows. Murder with use of a deadly weapon, victim 60 years of age or older. Guilty of first-degree murder with use of a deadly weapon, victim 60 years of age or older. Special verdict. The jury unanimously finds the murder willful, deliberate, and premeditated. The jury unanimously finds the murder was committed by means of lying in wait. The jury unanimously finds the murder was committed by means of elder abuse. Guilty of first-degree murder with use of a deadly weapon, special verdict. The jury unanimously finds the murder willful, deliberate, premeditated. Do you want me to finish this?
I'm just having the attorneys approach for just a moment.
Thank you, Judge.
Because
dated this 28th day of August 2024, signed by foreperson, juror number 2. Ladies and gentlemen of the jury, are these your verdicts as read? So say you one, so say you all.
Okay, at this time, ladies and gentlemen, the clerk is going to ask you a question. I just ask that you respond yes or no.
Juror number 1 is, are these your verdicts as read?
Yes.
Juror number 2, are these your verdicts as read?
Yes.
Juror number 3, are these your verdicts as read?
Yes.
Juror number 4, are these your verdicts as read?
Yes.
Juror number 5, are these your verdicts as read?
Yes.
Juror number 6, are these your verdicts as read?
Yes.
Juror number 7, are these your verdicts as read?
Yes.
Juror number 8, are these your verdicts as read?
Yes.
Juror number 9, are these your verdicts as read?
Yes.
Juror number 10, are these your verdicts as read?
Yes.
Juror number 11, are these your verdicts as read?
Yes.
Juror number 12, are these your verdicts as read?
Yes. At this time, the clerk will record the verdict in the official record of the court. And at this time, ladies and gentlemen, as you know, pursuant to your verdict, we will now go into the penalty phase of the trial. We're going to take a break and allow the attorneys to get prepared for that penalty phase. So we will start again at 1:30. At this time, you'll all be able to be back together again. You're going to go with the court officer back to the jury deliberation room. And at 1:30, we will begin the penalty phase of this trial. Thank you very much, and you're excused.
Thank you. All right, you're acting jury, please. Jurors, please go to the center.
Does the state stipulate to the presence of the panel, including the alternate jurors?
Yes, Your Honor.
And the defense?
Yes.
Okay, juror number 2, has the jury reached a verdict?
Yes, Your Honor.
Can you please hand the verdict form to Officer Hawks? Yes, please.
Thank you. District Court, Clark County, Nevada, the State of Nevada, Plaintiff versus Robert Tellis, Defendant, case number C-368-935, Department number 12. Verdict. We, the jury in the above entitled case, having found the defendant, Robert Tellis, guilty of murder of the first degree with use of a deadly weapon, victim 60 years of age or older, impose a sentence of life in the Nevada Department of Corrections with eligibility for parole beginning when a minimum of 20 years has served. Dated at Las Vegas, Nevada, this 28th day of August 2024, signed by foreperson, juror number 2. Ladies and gentlemen of the jury, is this your verdict as read? So say you one, so say you all.
Yes.
Does either side wish to have the panel polled?
No, on behalf of the state.
Mr. Jaskowitz?
No, Your Honor, thank you.
Okay, at this time, the verdict will be recorded in the official record. At this time, ladies and gentlemen, I am going to discharge you from your duty as jurors. Before I do, I want to extend my gratitude and thanks for your willingness to be here. It's a long trial. You were a very good jury. You paid attention, you took notes, and clearly took the case very serious in your deliberations. You are no longer under the admonition not to discuss the case with anyone. You're free to discuss the case, but you're under no obligation to discuss the case with anyone. After you are discharged, you will go back to the jury deliberation room in which you will be given further instructions. I do always like to give the lawyers an opportunity to speak to the jury panel, so I think it's always good for them to have that opportunity. However, it's up to you whether you want to speak to anyone. You also may have noticed that there was quite a bit of media attention on this case. So members of the media may reach out to you and want to discuss the case with you. I just want to make sure you understand you're under no obligation to discuss the case with anyone. But if you do want to discuss the case, it's up to you. So this time, ladies and gentlemen, you are discharged. Again, thank you very much for your service.
Thank you. All rise for the next jury. Adjourned.
The record reflects that the hearing is taking place outside the presence of the jury panel. At this time, the matter will be referred to parole and probation, and we will set it for sentencing.
That's going to be October 16th, 8:30 a.m. for sentencing.
Do the attorneys want that opportunity?
Yes, Your Honor.
Okay, we'll let you know when you can come back. Thank you very much.
Get on the ground! Get on the ground!
Oh, TC, moment.
Thank you.